give me that education I possible.
Of Education Act 1969, publish the places of credit education system not to be terminated without approval. So in this place, my contention is that the tribunal has 6 months only on the subject matter of termination, not on the subject of promotion. And coming to section 24B, the adjudication by the tribunal. This tribunal shall have jurisdictional power and authorities to adjudicate all the disputes and differences between the managing committee or, as the case may be, the governing body of any private education institution and any teacher or employee of such institution or the state government or any officer or authority of the state government relating to or the eligibility, entitlement, payment or non-payment of granting it only. So my case is not about granting it, you will see. So besides these 4 issues, other issues, this is the proper forum for adjudication, you will see. Now coming to the order passed by this honorable court on 6th of March 2025 in para 13. Para 13, this court has been very considerate, and the order is that taking into account the uncontroverted stand of the petitioner that employees similarly circumstances, namely Surendranath Sahu, has been regularized on the prospectus of materials record. This court is perused to direct for the regularization as far as said Surendranath Sahu, instead of directing the authorities to consider the case of the petitioner for regularization, which is normally the norm in service jurisprudence. Since this court is of the humble view that such a direction would amount to punishing the petitioner, which aged about 59 years and on the verge of superannuation into quagmire of litigation. Your Lordship, I am also at the age of 59 and on the verge of superannuation. So my case may be considered. Now, the order passed by this honorable court in WPCR number 5 of 2023 in para 11, it has been observed by this honorable court that it is also submitted that so far as maintainability of the instant writ petition is concerned, the Supreme Court in Whirlpool Corporation versus Register of Trademarks, Mumbai, and Urban Slab versus Indian Oil Corporation Limited has held that writ petition is maintainable even if alternative remedy exists on the ground that the writ has been filed for enforcement of fundamental rights. Your Lordship, my right to be considered for promotion.
Promotion is a fundamental right.
Yeah.
Promotion is a fundamental right.
Exactly, not promotion, but consideration for promotion
Is a fundamental right.
Under Article 16(1), yours. And coming to next, the report of Supreme Court of October 26, 1998, Corporation versus Register of Trademark. Either Raman is mentioned. Either Raman is mentioned.
We are conscious that the alternative remedy is not an absolute bar, but it is a discretion of the High Court whether to entertain the writ petition or not. So
Yes, sir.
discretion is always given. You are trying to interpret a particular provision, but if you read section 24B1,
Yes, sir, that's what I told.
please read with me. Please read with me.
The selected.
I am reading.
Okay.
Read with me. The tribunal shall have jurisdiction, comma, power and authority to adjudicate all have to consider all disputes
Yes.
and differences.
Yeah.
Then there is a comma.
Yeah.
Then skip some line. Then come to what all disputes and differences relating to
Yeah.
state or connected with eligibility, comma, entitlement, comma, payment or non-payment of grant in it. Now, what is the significance of a punctuation being used in a statutory provision? When a punctuation with comma is used, does it not mean that each words followed by a punctuation is an independent one?
Exactly.
Correct? So all disputes or differences relating to eligibility means you say that I am eligible to be promoted. So that's your eligibility. Entitlement, my entitlement to be promoted is an entitlement. So if both eligibility and entitlement are a different species, then this provision should not be restricted only to the payment or non-payment of grant in aid. You are trying to impress upon us this, that only jurisdiction is the payment or non-payment of grant in aid, because there is a punctuation in between that.
You not say that eligibility entitlement is next comes the payment of.
Comma is there. That's why I say the punctuation means what?
That is what.
Each word.
Yes, sir.
Each word has to be given an independent meaning. So payment or non-payment is one club. This is one genesis or genera, I would say. It's a genera. Payment or non-payment of grant in aid is a one genera. So you cannot, the entitlement and the eligibility cannot be attached to the payment or non-payment of grant in aid. Had it been, then there would not have been any punctuation, means the comma in between. This is what troubles us. Why the comma was put? To give independence to each word.
You not say the independently read, then eligibility,
Entitlement.
entitlement, payment or non-payment of granted. That is eligibility of granting aid.
That is why you are reading. Can you, when you say that each word is distinct,
Yeah.
can you club those words with the last one? You are clubbing it. The language would have been that all disputes and differences concerning the eligibility, entitlement, relating to the payment or non-payment of the grant in aid, what you are saying would have been the correct proposition. Once the word relating is appearing before the payment or non-payment, then it is restricted to a payment or non-payment of grant in aid. But once each word is followed by a comma, then what should be the interpretation given to that sentence? If they stand alone, independently, Then what? Then every disputes and differences must be relatable to first eligibility. Eligibility is a wide connotation. Eligibility of many aspects. Maybe some kind of an alliance, maybe some kind of a leave be granted to you. Entitlement to leave may be granted to you. If they refuse to grant you a leave, then what? That is what troubles me.
Your people have submitted this.
So you are appearing, you are a professor in physics. I understand this is a language which has to be. Please raising. Can you assist the court in this regard? The thing is very simple. I tell you, he was a demonstrator.
Yes, Your Honor.
He was a demonstrator in a college. Later on, he has been promoted as a lecturer. But approval to a post of lecturer was denied. Now, he approached the writ court, single bench. Single bench says that, no, this you have to approach the tribunal because the education tribunal is there.
Education tribunal.
You have to approach first. You cannot jump the forum or bypass the forum and file the writ petition here directly. So he has relegated him to go to a forum. Now, this 24B is the important book to the.
I think here book is. Not here. Okay.
Because what troubles me is this: the tribunal shall have the jurisdiction, then comma, power and authority to adjudicate all. It is not qualified that what dispute.
Right.
It is a wider one. All disputes and differences, then comma, between the managing committee or, as the case may be, the governing body of any private educational institution and any teacher or employee of such institution or the state government or any officer or authority of the state government. So this is what a qualification comes. But reading is that all disputes and differences, then comma, read relating to or connected with eligibility, then comma, entitlement, comma, payment or non-payment of grant in it. Now, what troubles us, because he's saying that relating or connected with eligibility or entitlement is actually connected with the payment or non-payment of grant in it. So, except the dispute relating to payment or non-payment of grant in aid, other disputes are not covered under this particular 24B because the tribunal does not have the jurisdiction. But my reading was when the eligibility is followed by a punctuation, comma, then entitlement is also followed by a punctuation. And then the payment or non-payment of grant in aid is a separate species. Eligibility has to be species, entitlement has to be a species, and then the payment and non-payment is another species.
Right.
So all the three are distinct. Your eligibility to be promoted as a lecturer, that comes under eligibility, or your entitlement to be promoted as a lecturer, or entitlement to be approved to the post of a lecturer is also coming within that word entitlement. That is what I feel is a importance of the punctuations in interpreting the statutory provision.
The indication of the word comma.
That is what that troubles me.
Independence.
That is what that troubles me. With that punctuation sometimes.
It says relating to or connected with.
Yes.
the eligibility, entitlement, payment or non-payment of guaranteed aid. So actually, I think the wording, the intention of the legislation is one. The wording, the comma is different, something different. In fact, what actually it means that payment or non-payment of guaranteed aid, if a person is eligible to get, number one, if entitled, number two, related to the payment or non-payment. Actually, that comma creates a
Confusion.
ambiguity, in fact.
Should have been end there.
Right.
It should have been.
Right.
It should have been and.
Correct. Actually, the intention of the legislation is not to deprive.
Like
a person.
But one has to understand, because the word all,
Yes, sir.
one has to understand the word
All
all
disputes.
dispute and differences, not quantified. It could have been the jurisdiction to adjudicate the disputes and differences
Correct.
relating or connected. All word would have been omitted. Then to some extent one can understand, but what all means a more expansive, more wider.
So I think payment or non-payment of guaranteed aid.
Is a one
Yes, but that
PC.
is, I think the intention of the legislation is to qualify if a person is eligible to get, number one. Another, if a person is entitled to get, number two. And any dispute relating to that, that means
that is what he wanted to say.
Right. All disputes relating to that comes within the purview of this. Well, that is the legislative intention, as I gather from the purpose for which the enactment has been made. Because the tribunal, otherwise, any dispute, so that may not come with the purview of tribunal. Tribunal can adjudicate any dispute, correct? But this is also 24B gives the power to adjudicate this.
Because that is the source of powers and jurisdiction. That is what we are grappling with,
Right.
what to do. If it is restricted to granting aid only, and then the eligibility and the entitlement is somehow intertwined with the granting aid, then I can understand. But can we give a restrictive meaning?
So because I have dealt with a lot of matters on this. For example, Mara, if a person who is continuing for a continuous period of 5 years or more than that, prior to the 94 amendment, the 94 granting aid provision came into picture, they were getting it on the basis of the government circulars and notifications.
Correct.
Sir, immediately after that, they want to find out whether a person is eligible to get it or not,
Correct.
or whether he is entitled to get it or not,
Correct.
by qualifying the period of employment
Correct.
by the concerned authority of the
No
school.
difficulty, no difficulty.
So that is the reason why they say all disputes. In fact, before Justice Arun Mishra in Supreme Court, in fact, in the division bench, I was arguing that matter. That granting it actually, so some persons were denied here in High Court. They carried the matter to the Supreme Court. Supreme Court said that this is beneficial legislation, they want to get it. But subsequently they set aside the same, saying that no, they are not entitled. Because this granting aid policy has been obliterated subsequently. A block grant has been introduced. Then granting aid policy changed in 2013. Now, in fact, must have changed the context.
So according to you, we should give a restrictive meaning.
Right.
But Your Lordship, when there are two conflicting interpretation of the statute of the law of the provision, one that favors the litigant should be taken into consideration. My submission, Your Lordship.
He has got some legal knowledge also.
Professor of physics, just imagine.
And he has been traveling from this court to that court,
Yeah.
and for many occasions.
2020
Since
Because the
2013.
difficulty, my brother, actually what he found that at one point of time he approached the tribunal and the tribunal decided it. So once you have approached the tribunal, but my contention was that if the tribunal lacks inherent jurisdiction,
Right.
even if a person has approached, that does not deter him from approaching the correct forum. Later on,
If there is inherent lack of jurisdiction.
absolutely. So that is what troubles me.
The tribunal
Yeah.
has also not decided the issue. the tribunal remitted matter to the government or the director.
No,
But anyhow, that was a decision to remit.
The order of the tribunal was to consider one case.
Oh, whatever,
Oh.
sir. That means the tribunal exercises jurisdiction
Ah.
by issuing a direction or the mandate upon the authority to do a particular thing in a particular manner.
Yeah.
So that means he has exercised and invoked his jurisdiction. I was on that. And what we are saying is the another facet of the law. That if it is a lack of inherent jurisdiction, then by conduct of the parties or by consent, the jurisdiction cannot be created. Had it been a pecuniary or territorial, that can be waived under section 21 of the CPC,
Inherent lack of jurisdiction cannot.
but it can't. Indispensable. Then what is the importance of comma? This is what troubles
We
me.
have to say, maybe the intention was payment and non-payment of granting it can be kept in a bracket,
True.
so that eligibility entitlement.
Is somehow intertwined with it. This is what he is saying.
No, that is,
He's saying the same thing. No, that's true. If your perception is also, then
there may be sometimes, with due respect, my lord, there are certain provisions of the statute where this local press people who print it, they commit mistakes.
oh no, that is what is
Sometimes
there.
it happens, sir.
It happens. I have come across.
As a matter of fact, on the basis of that printing mistake, Supreme Court has delivered a judgment.
Sir, I can give you an example of house where there is one provision under the West Bengal Land Reforms Act, Section E, which gives a right to the Vargadar means who does the cultivation on a sharing basis. What terminology is used here, I do not know. But
Right.
there it is called Vargadar. And then the co-sharer of the plot and the adjoining owner, they have a right of preemption in the event the agricultural land is sold to a stranger.
Right.
So the word was that the co-sharer can apply for a preemption under section. If the other co-sharer has sold his share or a portion of the plot to a third party.
Okay.
So the word of was misprint. So the one of the honorable just saying the share of or of a plot or a portion of the plot. So of means there if he sold the entire share, then
That would have been
it
different.
is excluded. But the actual word was share or
A portion
the portion of the plot.
of cannot be.
Of was wrongly interpreted. So sometimes the printing mistakes
Yes.
creates a havoc.
That is effective.
But I do not think that it is because I do not find from this provision because had it been a tribunal either under Article 323A or 323B, the position would have been because there will be a separate act to be enacted,
Independent act will be.
independent act, where like an administrative tribunal, the power akin to 226 and 227 is also vested.
Yes, because that is derived from 323A and
A,
G.
because even a virus can be decided by the tribunal. Very interesting. Administrative tribunal under 323A. 323B is a different where the land related tribunals,
Right.
these are the tribunals which are coming under this. So there is an act which can throw a light on the object and the purpose behind it.
Right.
Here, by virtue of introduction of the section, and the object and purpose is not, then we have to go by the debate by placing a bill for amendment.
Legislative council. But I remember one incident, in fact, my other side actually, Advocate General of Bihar, in fact, you were challenging an NGT matter before the Calcutta High Court. So it was before the Honorable Chief Justice. So Honorable Judge said, do we have the assignment to hear the matter? You said, it can be hard as a jurisdiction. Court said no. The tribunal constituted under 323A and 322B are assigned to us. But the tribunal constituted otherwise goes to a single judge.
Correct.
As a result of which, NGT has been created by that Supreme Court directive after this Bhopal gas tragedy. And therefore, the matter was gone to the single judge.
It was. That is the Calcutta view. That if there is anything apart from the 323A and 323B, then in that event, every tribunal, there are many this metro railways claims tribunal. There are tribunals which are the statutory tribunals under the statute.
Absolutely.
So that goes to a single page, Article 226. L. Chandra Kumar does not come into it.
Yes.
That constitution base does not come.
Doesn't come.
That is the first judgment which says it will go to a division bench. Anyhow, let me ponder upon the thing. You also ponder upon the thing. What do you think about this punctuation? Because I have delivered one judgment on punctuation. That while interpreting the statutory provisions, the importance of a punctuation is also to be taken into account. I tell you, you have a civil background, so that is what.
Sir.
So do I. You find that under Order 43 Rule 1R,
Right.
this Order 39 Rule
1.
Order 39 Rule 4, Order 39 Rule 2E.
2A. Publishing.
These are all applicable orders.
But it's Order 43 gives the power.
By virtue of Section 104.
104. Substantive right and
Right, and the procedural. What happened? That there was an order by which Order 39 Rule 1 and 2 application and Order 39 Rule 4 were disposed of. Now the question arose whether the single appeal against the two independent orders would lapse.
So it depends on the relief, with due respect, Maran.
One is vacation of the
Correct.
orders because of.
Once there is an existing
suppression,
order,
that is
once
a
there is an
different
existing order,
consideration.
4 doesn't come into play.
That is what I'm saying. So 4 has a different
Yes,
altogether
different.
consideration. Order 39 Rule 1 and 2 different consideration. Now both were disposed of by a common bench. So the question arose, are you always a troublemaker? Invite the troubles. So I just put a question, whether the single appeal lies.
So that is exactly the reason I say, if the prayer is to modify, it is not available. Unless 39(1) order is passed, question of modification doesn't arise. So here, by mentioning 4, doesn't make the court the power to pass an order which modifies an earlier order. Therefore, I think single appeal will lie. Because 4 doesn't exist.
Then the question was the comma. There it was comma. Because one has to understand the different parameters of consideration.
I understand. So in fact, Order 39 Rule 2 is Order 39 Rule 1 and 2, both are independent.
Absolutely. Absolutely.
But
No
sir,
doubt about it.
all the persons are written.
But the conjunctive word is used and of two.
Right.
That is why the conjunction is creating a one. It's a one, I would say the species or a genera. It is never used in a disjunctive manner. It's always used in a conjunctive. So there, that question arose. I believe that was a judgment which I delivered on that particular punctuation.
I don't see what's your book teaching. It is a concept file HE, it about 1990 file HE. I think.
No, he is litigating. There is no difficulty.
So we are
Sometimes approaching the tribunal, sometimes approaching this board. But there was
Yes,
a first appeal also under 24C is a first appeal. That
Yes, yes.
24C is a appeal promise.
In FAO, there was also a decision. There was a decision of this
If
court
you,
in FAO.
Actually, you will not see the FAO that has filed in the 25. The order which that no appeal lie against the order of the director. So accordingly to this.
So go to that.
By the time I came to such position of law,
There was no decision as such.
the time
Right.
to file a revised FAO was
Till
exhausted.
now, except
Then I had to file the
this improved
appeal.
order,
I
till now,
have reached.
Mr. Till now, this order which is impugned here,
Yes, sir.
that is on merit. Till now, there is no order with regard to your merits.
Can you bring that judge?
Yes, sir. It was decided in merits.
210. Now this page 213.
Yes. And Lordship's judgment, Lordship delivered on that completion miller. My lord sister, Ms. Kass has given me that judgment. Lordship delivered in the case of Dipendranath Basu versus Eastern Railways Miller in 2011. That judgment we have got.
What?
On that punctuation, Lordship's judgment.
Yes,
In Titan.
yes.
Yes.
My judgment.
Yes, ma'am.
So that's why I'm saying I have delivered one judgment on that. That is,
In 27/7/2011. Dipendranath Basu versus Eastern Railways.
just after my becoming a judge.
Yes.
Or departure from that cycle to this cycle.
Lost the bar and came to the bench. In fact, it's reciprocal.
I have some reservations on the word elevation. It's maybe an elevated platform, but it is the same thing. It's a slide which
And
has,
that's why it's a reciprocation.
it's a slide which has changed. Mr. Mishra, you also please ponder
I'll-
on this
I'll-
nuance. Mr. Mishra, you also please ponder
I'll-
on this
I'll-
nuances of those punctuations.
I'll-
where the comma is used.
I'll get your lordship judgment, also find out if anything thereafter.
You come after 1 week, let us ponder upon this because it will have some impact. Some impact, because if we deliver a judgment, it will really close the doors for
Yes.
many. And it has a larger impact,
In fact,
not your case, but all in future. So let us decide this.
I'll be there on the next date. If your lordship fix a date,
But just think about it.
Urgent to 11 September.
You come across with any decision of this court. You have been doing many litigation matters.
Right.
And service related to service matters also.
Right.
So, what is the scope and ambit of education tribunal vis-a-vis service and
Okay, Lord.
as well as promotion?
With your lordship's permission and permission of the honorable CJ in this regard, where since my lord senior has been there to assist your lordship's my lord. So my lord, here my lord, what I have heard by sitting here, his case is relating to his promotion from the post of demonstrator to that of the lecturer. Here my lord, the question of eligibility is a factor because he has to come within the ambit of that 8(2)(b). So that is a stage which is much prior to his becoming entitled to the benefits of granting aid, which will come at a later stage, subject to his satisfaction of eligibility. That is why the comma used in that sentence of 20.
Now you are not a item with the senior.
Well, since your lordship have given me an opportunity to address your lordship,
The institution.
well,
Not
grant.
employee specific.
Sorry.
Isn't it?
Well,
Granting aid
all
is to the institution.
Institution.
Not employee specific.
not institution specific at the initial point of time, and the individual concerned who ultimately claims that granting aid, he has to satisfy the eligibility prescribed. And here, my lord, the eligibility doesn't come automatic because that for that purpose he has to come through the rigors of 8(2)(b), and here he has stopped. He has been stopped. Whatever I have heard, my
That
lord.
is one. That is one.
That is we are thinking about the jurisdiction of the
Forum.
whether the
Yes, sir.
eligibility
Yes.
can be interpreted
Yes, my lord. My lord, why?
You are saying that the eligibility while interpreting, because the senior advocate, Mr. Vishnu was also propagating that,
Right.
the object and the purpose. He was also saying, and that was appreciated by Mr. Vishnu, the senior advocate to him.
Right.
So he's saying that the purpose of the object, one which inures to the benefit of the say the employee, the employee, that should be taken into as a benchmark.
Right.
One should treat it in this way, not to rule out everything.
My lord, here, my lord, the State Education Tribunal is a creature of the Education Act itself. It's,
True, that is what
yes,
I'm saying.
yes, ma'am. Yes, my lord. 24B starts with a beginning clause, all disputes, and it has been further qualified by eligibility, comma, entitlement.
That is what is the now importance of that comma.
Yes, ma'am. So that
Can
is
they be treated separately
yes.
or be treated conjointly with payment and non-payment of grantee? That is what where we are stuck up.
My lord, my humble submission before lordships would be, it would be separate, and claim of grantinate comes at a later stage. So prior to that, all these disputes, which includes
Then in that event, if it comes the latter on, then the approach towards tribunal will be a premature approach. The tribunal cannot exercise its jurisdiction until there is some kind of a denial.
my lord,
Suppose a authority has denied that your entitlement is not there, then what will happen?
my lord, my humble submission would be, unless and until there is a dispute between the employee
Here
with
is
the
a
management
dispute relating entitlement
relating to
and eligibility both,
relating to
because
eligibility as well.
both are involved. The authority have denied that you are not entitled to be approved to the post of a lecturer.
Yes.
That's an entitlement that comes.
My lord, the authority might have used that word entitlement there, but my lord, there are judgment laws of this honorable court which says eligibility and entitlement are two different contexts, the concepts, and eligibility has to be satisfied before somebody claims that entitlement. And here, my lord, my humble submission for subject to your lordship's acceptance, an employee has to satisfy his eligibility for that particular post.
So suppose he failed to satisfy.
Right.
What is the forum?
Education tribunal. So the tribe.
What is the big mark we are grappling with?
Right.
Is a big question mark we are grappling with.
Yes.
Whether the remedy is the tribunal or the remedy is 226 status.
Now, is there any decision of this court earlier on this issue? That is what
Well,
with regard
If you
to
want
forum.
to just know, because from the book I come across with this judgment.
Yes.
Which says that the dispute relating to appointment or cancellation of appointment
Yes.
does not come within the jurisdiction of the tribunal.
Tribunal.
Yes, sir.
So that is what I was grappling with, the word entitlement or the eligibility to be appointed, whether it comes or it does not come.
Subject to that the decision, the rendition
This is
made.
Gokulananda Panda versus State of Orissa.
My lord, subject to that rendition given in that judgment, here the word is relating to appointment. Appointment has got nothing to do with that education tribunal or that it's not a dispute. Appointment is at the initial point of time.
I believe is the Oneshwar Pradhan's case, which says that the jurisdiction of the tribunal on a matter relating to denial of grantinate to the post of a lecturer held by the petitioner. The matter first comes within the jurisdiction of tribunal.
Well, that is with regard to the grantinate. But even here, my lord,
Denial of grantinate to the post of a lecturer.
yes, my lord. That, my lord, subject to lots
So
of.
here is when he says no approval to the
Yes.
post of lecturer can be granted.
Yes.
Does it not imply that there is an implied refusal to provide a grantee?
My lord, one example.
Is another
My lord,
aspect.
one example, my lord. Suppose in an institution, as per the yardstick, this number of posts are there. And the institution claims that no, because of this type of student strength, we need a more post.
But that post has to be sanctioned. first.
Yes, my lord. That is why. Yes.
Then the appointment to a non-sanctioned post does not create a absolute or a vested right.
Yes.
We are conscious, sir, that is a different aspect.
Yes, ma'am.
The difference. We are simply adjudicating whether he comes within the jurisdiction of a tribunal or he can come to the straight court, state. That is what we are. We are not going to decide on that.
So then, in that
It's a
event,
jurisdiction for us.
we have to go to that amending act by which the 24B has been
When we
inserted.
raise the issue of object and the purpose, then we have to look at the bill when it was
Yes, ma'am, because
placed on the House of Vidhan Sabha
my,
and what was the debate which really.
because prior
Get it.
in the original act that was not there. In the original act that was not there. Because this adjudication was being made by this honorable court. After coming into force of this particular provision, all these cases which were pending before the High Court, this honorable court, stood transferred to the tribunal for adjudication.
Yes, I do not know from that, must be from any kind of a order or something like that, I do not know.
Yes,
We have to see the amending act as well.
yes, ma'am.
Yes.
Yes.
We have to see the amending act,
Ma'am.
by virtue of this 24A, B, C. was
Yes,
introduced.
yes, ma'am. So the government can very well place that for your
Because
lordship.
they are in the law department.
It is available. Ma'am.
Need an amending act.
Yes, 1998, Orissa Education Amendment Act 1998,
Yes.
along with bill.
Yes.
In
To-
that bill, there will be.
The reasons.
Statement of objection reasons
Yes.
also.
Reasons.
The knowledge that can be shared by all these lawyers.
Item 2.
Last occasion, also for the time to obtain instructions.
In this case, I have obtained instructions. In fact, we are going to make payment of whatever dues the petitioner has raised. But we require a little time. That is the only concept. And we've asked.
Waited for such a long time, you can wait for some time.
Yes, right. The work was three.
What do you think?
Oblige.
The matter was the roll on the last.
Let this test be followed along with WP 64793 of 2020.
You are assailing the violence of.
Same fire is under challenge. Yes, ma'am.
Where it is, that matters.
Well,
I have. The way you have drafted the petition and wanted to challenge the violation, I'm really surprised with whether that can be a ground to declare a provision that has ultra virus. I have seen 54 line.
Here in this case, I have taken one ground that there is no, since they are directly recruited to the populace, can they be thrown out by some other mode
Obviously.
in absence of a provision available?
Obviously.
Well, that is what
Obviously.
But so far as the provisions of 243 are, it does prescribe that.
Can't be, then there are many things. Then we have to ponder upon.
So why don't we call this matter along with that so that both the cases can be disposed of.
Where is that matter?
47 WPC 4793 of 2025.
And if you listed ever.
Well, that 4 times it was before the other bench, the division bench, and now it is pending. And not recently, when the assignment was before the other bench.
23rd September.
It is the people of the area who should give you a mandate whether to be there or not to be there.
But not,
A authority cannot remove you. That is your case.
well, that power which was inserted in that act, that is not available, delegated by the constitution. That is what we say.
And under the election dispute, an elected person, he is declared as disqualified or he is removed
Yes.
by one stroke of the pen. Then it should be a mandate of the people. The question is that the system is put into place where the mandate of the people are given. If the majority peoples have decided to put a particular provisions or the procedure, can it be said?
Under the constitution, the state will authorize to do a particular thing.
And let
Whether
us
it can travel beyond that.
Panchayati Raj, how far you can go. Let us,
But it's not a case of panchayat raj, it's a municipality.
anyhow.
So it stands on a different footing than panchayat raj.
Anyhow,
Obliged.
let us see.
Okay.
Item 4 is adjourned to 23rd September.
Yes.
No, it's a municipality meeting. Obliged.
Item 5.
The fact of the case may not, the petition is a contractor will also. And the tender work to the extent of 2 crores 90,000 was allotted in his.
But only 2 sites were not allotted.
You know,
2 sites were not allotted. Is
yes,
it that case?
that is 2 millions.
And
2 sites.
one site which was given, there is a flood.
Yes, million.
So you could not.
No millions. Commencement after 7 months, the first site was allotted, was given,
What I'm saying.
and he did it. And the second site was given after the stipulated period. And because that is also not visible for the construction of this reservoir. So they have given that that land is not suitable for reservoir. So they cancel. Third one is also, there is no passage, they also cancel. So this site they didn't give it and stipulated period is over. So I pray that because the stipulated period is over, so let it be close this contract. And because of close the contract and pay my areas to the extent of 1 village that I have already completed. That is fine. Only I have given this repentance.
Some instructions were not shown. No.
That is the general remark. If you are unable to give him a site where he will put a construction. And whatever sites you yourself knows that it is not suitable. And then you are finding the alternative sites. You are unable to find them. Why you keep the contract open for him? Because there will be a price escalation. He cannot be put to such a accomplishment. Geopardy.
Almost 2 weeks I'll seek instructions were not shown.
16th September.
Yes.
Item 6.
Right, please. Arbitrary cancellation of a tender is under cancel. The government of Odisha issued.
was not issued.
So after I was declared L1 bidder, there were 5 works that were issued in the tender notice. 5 different works. I applied for 1 work. There were 13 L1 bidders. After these 13 L1 bidders were declared, there was a lottery. In the lottery, I was declared the winner.
Thereafter, it was found that it has not been done in a fair and
Yes, sir.
transparent manner.
It has only stated that there was some discrepancy for which it has been cancelled. No reason, what discrepancy, nothing has been.
Can it be? Does it require?
Your Lordship is arbitrary. Lord.
Arbitrary in that is what is there.
Your Lordship may kindly see the proceedings of the tender. Kindly come to page 31. Subsequently, a transparent lottery was conducted among the 13 L1 bidders on such and such date. In presence of 5 numbers of L1 bidders, along with other officials, there is not a single complaint, Your Lordship, about any discrepancy. Later, the procurement committee recommended that this person who is declared as the winner of the transparent lottery must be given the tender. Thereafter, Your Lordship, the observation and recommendation of TC cum EC, tender committee and evaluation committee, it says,
Have you read the judgment of three judgments of the Supreme Court, the recent judgment of 2024? Both Kumar Singh Rathod or of Justice Chandrachud, I believe, as his lordship, that then was the subject. And Justice.
Yes, Subodh Singh Rathod versus Calcutta Municipality.
Subodh Singh
Rathod.
Subodh Singh.
24.
20 is 24.
24.
Yes.
24, that is party wala. Along with
Justice
Chandrachud and
Three wins.
Three judgments.
Yes, three
No. There, the second point, there are 2 points which were decided. Second point was this: whether the cancellation of a tender invites the judicial review to be invoked.
Your Lordship, if it's arbitrary, well,
There, the question was, then they say what should be termed as an arbitrary and what should not be termed as an arbitrary.
the cancellation of tender on 900.
That is what the direct point. Please read the
Of course,
judgment.
I'll read it.
Don't argue without knowing anything.
I'll read it.
There are some things which is said in your favor, there are something which is said
I will go.
against you. Please go and read the judgment. Subodh, huh?
Subodh Singh Rathod.
Rathod.
Rathod. Chief Executive, Calcutta. It's a case from Calcutta.
That is a eastern EM bypass. Please read the AIR 2024, citation.
This is also in SCC available 2025. But it's just that presently not.
Kumar Singh Rathod.
Yes.
I'll find it out.
2024 SCC online SC 1684.
Not reported in SCC.
Not.
Anyhow, please read.
I'll.
That judgment actually was the previous judgment.
I will go through that.
Right from 1955, 59 probably, or 52, I do not remember, where the Supreme Court was of the view that it is the freedom of the state to cancel it, proceed with the tender or not to proceed with the tender. The participant cannot dictate that what to do and in what manner it should be. But there has been a shift already. So that is what the evolution has been. The what reading judge?
I will not operate.
My lords already heard a matter. I was asking the lordships in this matter relating to cancellation of the tender. That wraps company matter. That was discussed with that.
So both was discussed. Yes. Maybe that's my memory that goes. Yes. Is probably.
In the meantime, they may also take instructions. In the meantime, the state may also take instructions. I'll come back after reading this.
In Noida, all this company.
2 weeks.
Yes, the state may take instructions.
Thank you.
2024 7 SCR 530.
Item 6 adjourned to 18th September. Item 7.
After completion of bidding process, the tender has been approved subject to the connected rate petition. For that reason, they have not allowed, even approved, they have not issued a order.
What is the other?
Connected rate petition will not be permitted to withdraw. Connected rate application will not be permitted to withdraw. We'll file just came on.
So annexure 1, your lordship, page 17.
And
Yes,
then this repetition will have no meaning.
in view of the observation, because
No, if you withdrew, then there is no pending
yes.
straight away.
Yes.
So it will be, let him file the memo
I'll
first.
immediately file.
Please file it first.
Manu.
If he files that connected should be withdrawn, this matter should be placed tomorrow, so that will process.
Yes.
I'm good. Item 8. Item 8.
This is a writ petition in the nature of public interest litigation. No, the opponent
Consider your representative.
No, my lord.
The public interest litigation.
No, my lord, not consider my
The first thing
representative.
is
The,
to forthwith consider and decide the petition of representation.
my lord, the allegations are a bit severe in this matter.
Wash and set aside the illegal diversion.
Yes, ma'am. Because the fund was allocated for renovation of the next temple.
And it has been diverted where?
It has been bifurcated and diverted once towards the construction of a gate and the other for construction of a road. The whole fund of 4 lakhs, which was for the renovation of the Ganesh temple, has been completely utilized for these two purposes.
What is the status of that particular temple?
I'll have to say.
Structure as well as the sanctions and so on.
Lord, I'll take instructions to that. I'll take instructions to that. My lord may permit me. It's come for the first time. I'll obtain what is the status. My lord, I have also, if I may be permitted to place it. So the work that is going on, he'll take away
The thing
the.
is that if it is allocated to it, then can we reallocate that fund for that purpose? That's the only thing. You can't say that they cannot construct a road if it is necessary. Only thing is your concern is this money should be invested and utilized for this renovation of the Ganesh temple. So they may allot this fund again. Yes.
17th September.
Much of this.
Item 9.
Oh. Panchayat Samiti accounting procedural rule. Challenge, declare. What your legislative bodies are doing. All these acts are declared unlawful.
Well, without examining the principal statute.
Can come after 2 weeks.
18th September. Item 10.
The petition will come against his technical bid rejection, who is a partnership firm. his bid was rejected, case 23 Annex 1, on the ground that bidder has applied exemption of EMD in the e-procurement portal and uploaded the BG document. And the RC, the petitioner who is a partnership firm, participated in the bid. The rejection was made that he applied for exemption of EMD and but uploaded
he deposited EMD.
bank guarantee. The
Bank guarantee is permissible.
as per 34, it is permissible, my humble submission.
Where is the 34?
Page number, page number 49.
49.
Annex 3 also. Clause 34, Roman 2, Miller. The 10th line. Of page 34 2, Miller. Page Miller, 10th line of 34 2, Miller. Plus 34 Roman 2. The EMD, initial security or any other security may be also taken from the contractor in form of NAC, post office saving account, post office time deposit, Ishan Vikas Patra, or bank guarantee / in favor of the divisional officer from the national security.
This is EMD.
Unless money was EMD.
So how can you deny? Suppose he has asked for an exemption, but actually he has submitted it.
That today morning I have spoken to them. They have said it as non-responsive. But in the meantime, if your lordship will find, that is at page 23, the date for opening of the financial bid was fixed to 14/8. What has happened thereafter, I have not received that instruction, because in the meantime, must have been opened and page 23, the last line, if your lordship will.
Yes, tell us on Thursday.
4th September. Item 11.
Now, pertaining to law. I was so qualified in technical bid. Later they disqualified, the opposite party disqualified me on the ground that there was separation of fact. My humble submission to lordship is that the separation of fact as is found that has been stands obliterated by the apex authority, that is opposite party number 1. The saying the documents which were filed with, if any bidder has filed any document that is pertaining to voucher or showing purchase of shutter plate, that should be treated not applicable. That means the apex authority, like opposite party number 1, that categorically states that if any bidder has filed such document, that will be non-existent, that will be treated non-existence. While relying upon that, on a complaint made by the person lateral com, that the that letter says the complaint is made by any aggrieved bidder. By my humble submission, the application complaint raised by the opposite party number 6, that is the bidder which has been qualified, he is not a bidder aggrieved. So any complaint, bidder aggrieved.
Oh,
Aggrieved bidder, aggrieved bidder.
because of your disqualification, she is not a bidder aggrieved.
Blood by because of the he raised a complaint before the opposite party that I filed certain document which is ingenuine. My humble submission that the petition is crystal clear that the objection shall be entertained by the aggrieved bidder. But that complaint has been waived off by the opposite party number 1, saying any document filed by the bidder that would not be applicable. I invite your kind attention. Hello?
Actually, we are unable to comprehend what
Yes,
is
yes.
really.
My humble, my disqualification.
There was no confusion or ambiguity at the present, initially, but it has now aggravated.
My humble submission that the opposite part number one,
Sir, tell me that there
Yes.
was tender which was published inviting
Tender-
bids from the different persons.
yes,
You, along with opposite party number 6, submitted the bid,
which one?
right? You reached to a technical bid stage,
Success.
correct? Where the authorities have qualified you and him both at the technical bid stage. You went to a financial bid stage.
Yes.
In the financial bid stage, opposite party number 6 has been found to be the successful bidder.
In technical,
Financial bid,
financial bit not yet.
not yet. Okay. So both are there. Then,
Yes.
then opposite party number 6 has made a complaint
Come,
that you have given
ingenuine,
ingenuine documents or fake document, fabricated
Yes.
document.
yes, that was the complaint.
That is one. Now the authority have disqualified you.
Yes.
How they have disqualified?
My humble submission that the document, opposite part number one,
That is a voucher showing
How-
the purchase of certain article.
yes,
So they say that the voucher is a manufactured document.
manufactured the same.
Correct.
I explained that, but that applicant, my representation is kept lying with them for consideration. At this point, the OP number one, my lord,
Who is he?
OP number one is the apex, highest authority.
Who?
Oh, government. Lord. May I invite your kind attention to the letter.
Whatever.
Tender inviting authority.
Yes, tender inviting of authority is the OP number 4, but the apex authority, when the work under which department the work is being done.
First secretary.
Yes, that is the Lord, page, we may invite your kind attention to the
Department.
page, OP number 1, opposite part. My lord. That letter I am, sir.
So where he says that the objection raised is not tenable.
Yes, that is it. Not tenable,
Not tenable.
not tenable.
Then you are qualified.
Yeah, well, but they have not qualified. That is my,
So what is your remark then?
they have not qualified, that disqualified me. Overall, that disqualified me without relying upon the direction of the opposite part number 1.
Where is the
Yes,
direction
page
of
90,
the
page
party
90.
number?
Page, my lord, annexure 9, page 156, my lord. 156, my lord. Sorry, my lord, I was straight way. Open 156, my lord.
Is addressed to see.
9, annexure 9. 156. Hello.
It says that if any documents what the shutter agencies are uploaded, that will not be taken into consideration at the time of technical evaluation. So they have taken it.
Yes.
According to you, they should have just thrown in a dustbin.
In view of this letter.
They should have thrown in a dustbin.
But that should that it may not applicable, that means it has been
It doesn't go into the
Falsity
consideration.
or
no more a condition.
Evaluation process.
That may not be treated as a condition of the.
It's not warranted for evaluation process.
Yes.
My lords, he was initially he was technically qualified.
Yes.
Thereafter, on 17th January
Sir,
2025,
According to you, these are manufactured documents so far as the voucher to purchase the shutter plates are concerned.
yes, ma'am.
If this is the order which is of the ethics body, this says that if he has purchased, don't go into the falsity of the genuine. Don't consider it.
Diploma.
Just ignore it.
Diploma.
Then how can you discover?
That is government letter.
Chief Engineer
Government,
in Chief,
sir.
Office of Engineer in Chief.
That is the office.
Rural works.
Government of also.
Rural work.
Yes, ma'am.
Chief engineer.
Yes, ma'am. Chief Engineer.
His body. So can you ignore?
My
This
lords,
body writes to the chief construction engineer. the tender calling authority.
My lord, if I may only refer to Annexure 6, my lord, page 32. Page, that is the impugned letter, my lord, 17 January
You
2025.
have said that he has given a manufactured,
No, the only language which is used is suppression of facts, my lord.
what suppression?
That details it's,
What suppression?
That-
Then you have to say that what he has
yes,
suppressed.
my lord. Yes, my lord.
Then we are quashing this order immediately.
No, my lord, I'll have to take instruction on
Said that
what.
Annexure 6 is of the month of
Jan-
January
Yes, ma'am.
25.
Yes, my lord.
Thereafter,
Yes, my lord.
government rights or chief engineering chief, works department, rights to the construction. This is subsequent letter, is in the month of May,
Yes, my lord.
so which will prevail.
My lord, that
This letter
Yes, ma'am.
says that in the evaluation process, that document is
should not be considered.
redundant.
Yes, ma'am.
Then
Only thing.
what remains?
Only thing is that this is a January 2025 technique. It was he was disqualified on January 2000.
So you should
Subsequently,
withdraw that.
my lords have to take instruction of what are the suppressions and
Day after tomorrow.
yes, ma'am.
to take this.
4th September.
In the meantime, like that.
They won't do anything.
It's in the price
This
negotiation.
scheme has already been done, sir. January
Yes.
rejection. You are coming in the month of September. So nearly 8 months have already gone.
Yes, that
It
I,
has been done. I do not know. Then why you do not? Why?
I was rushing to the court, so I could not reconcile. And after tomorrow, we also.
Item 12, disposed of as withdrawn. Item 13,
Information lordship, instructions, your lordship. They have given us an instruction, but they have a lot of technical issues, your lordship. So we were thinking that we should file an affidavit to that effect, your lordship. The department explained it.
I will do the research and do.
Yes, your lordship, those are we were, speaking with the additional secretary, your lordship, she was explaining to us a lot of technical issues, so I think we should.
On certain research papers and the articles, the authenticity is very difficult to be ascertained.
Yes, your lordship.
Nowadays, the difficulty is that we don't want to, authenticity cannot be established.
Yes, your lordship, they had a similar expert
You have a
from.
team of the experts who are the experts in this line. and
Yes, your lordship. Yes, your lordship, the Ames Delhi and a lot of other experts, they were put together and a committee was formed. They have given an opinion with a lot of deliberation expert deliberations, your lordship. I thought we can put it down in affidavit, your lordship, explaining the difference, your lordship, and the.
Find a surgeon.
Yes. Over like
Surgeon within
2 weeks, your lordship.
17th September.
Yes.
Item 17,
Last conclusion, in this case, I was, this is the computation whether this will come under monetary limit or not. Today also I have discussed with them, they will be sending in a writing that it will be, we have to urge this matter, your lordship. So I need,
We have to urge this matter.
we have to argue this matter, your lordship.
Why?
Because it doesn't come under monetary limit. I have that instruction, so I need some more time to.
Only the document is to be given, so there must be a conscious decision by the authority that up to a particular. Pecuniary or the amount. They will not.
For that it is, in this case, we have to, we won't withdraw this case and we have to argue this case.
Even if the mandate of the authority. is there,
It is above 2 crores. The demand is above 2 crores, your lordship.
Then what more instruction? If it is above 2 crore, that does not count, then argue.
Your lordship, I need 10 days, only 10 days.
Is your bill
It's a departmental.
Department, okay.
Ah,
Plus it, whether to admit the question or not.
some instruction is also being receiving in this matter, Your Lordship. Only 10 days.
Limitation.
We've got 18 days. 18 days, Your Lordship. That is it.
There's a control.
I can't remember, Your Lordship. Oh, bless you.
15th September. Item 18.
My lord, appearing for the petitioner, my lord. My lord, next.
Memo of Advocate Mr. Karthik Kurmi.
Yes. My lord, may I submit, Your Lordship?
Yes,
My lord, may I submit?
yes.
My lord, the central issue involved in this case is that on 3 grounds, the demand has been confirmed in respect of which no demand or amount was specified in the show cause notice. And traversing outside the show cause notice, the tax has been demanded on 3 counts, Your Lordship, which were not forming part of the show cause notice. That is a central issue involved in this case. So that is contrary to section 73(1) and 75(7) of the CGST Act and OGST Act, my lord. So, my lord, Your Lordship would kindly see.
Subject to permission of my learned senior. Your Lordship, my learned senior, the petitioner has filed an additional affidavit in this case. Your Lordship, this additional affidavit, I have received also the copy. I have a small objection, Your Lordship. On the last occasion, also I have raised this preliminary objection. Your Lordship, so far as the.
You want to file objection to?
No, not necessary, Your Lordship. Only one paragraph, let me show Your Lordship what happened. So cause notice have been issued, assessment order, adjudication order has been passed in 2024. Subsequent to that, he has filed one rectification application under section 161. The complete application in the writ petition has not been enclosed, could not be enclosed. The complete application has been enclosed in this petition. So, Your Lordship, for a moment, have 10, the additional affidavit, page 44, Your Lordship, I kindly looked into.
What for?
Where he has himself stated.
So that is on merit.
Not me. So far as the appeal, they once there at the time of filing up that application, they have reserved the right to file appeal, Your Lordship. So 161 application, petition order is appealable. So let him file appeal, only that submission, that objection I have.
So unless they file an appeal, then the order which you want, that cannot be assailed.
No, Your Lordship.
Then?
That is not, themselves, they have written that.
They have undertaken there. They have undertaken there.
Your Lordship. In 161
So that will preclude filing of writ application.
No, preclude your Lordship. Since it is appealable and 161, Your Lordship consistently relegated the matter to the appellate authority.
We are conscious any decision or any order is appealable. But Mr. Ganesh has given me a copy which is incomplete, not fully.
So that is the reason actually we want.
You have made it dash. What dash I will read?
No, that's so that is the reason actually.
Annexer dash.
We have filed a memo after that, that's indicating that correction actually.
So this is the way it is done. Annexers are enclosed forming part of writ petition in pursuant to additional affidavit.
Pardon.
Or amendment application you have to file. You have to seek leave of this court to file additional documents.
I completely bow down to your lordships. Absolutely correct.
These are very interesting procedures which have been innovatively devised here, that the annexures which do not form part of the main petition is being filed through a memo. If there is no sufficient pleading, can it forms part of the record by virtue of a memo? Importance of pleading, because these writ petitions are decided on an affidavit evidence.
Yes,
And this must form part of an affidavit.
absolutely.
Then, by virtue of memo.
No, we have brought it in the form of an affidavit.
Affidavit is,
Where is the memo flag B? You have brought certain documents.
can that be dealt while passing any order or judgment?
My lord, may I just throw some light on that, my lord? Just may I
Mr. Kurmi is
clarify?
arguing on the basis of this documents.
My lord, may I clarify, my lord?
Yes.
In fact, the rectification order was part of the writ petition. One page was inadvertently not annexed in the writ
So
petition.
memo. So by virtue of a memo, can it be?
So pleading is.
I am asking that whether by virtue of a memo it has to be done. Then we'll have to eradicate all the provisions of the pleadings. The importance of pleadings in a judicial system that has to be completely overridden.
My lord, pleading is there. Only
There is
one
no
page-
pleading. How can you? Are you aware of an amendment provision under Order 6, Rule 17 of the Code of Civil Procedure?
That's very much clear.
How pleadings have to be made? How the documents are to constitute a part of the pleadings? How can it be done by virtue of memo? There must be some pleading in this regard that there was some inadvertently, it was not done. That should be treated as there should be an application with the prayer for that.
In the additional affidavit, that is clearly mentioned, your lordship.
It's not, there must be an application substantive with the prayer to treat it as a part of it. Not by way of an affidavit.
Pages won't match. Then chronologically
No,
make it.
it's not.
Pages
Then
won't
once
match.
it's the importance of the pleadings and those procedural aspects.
Sir, where shall we include this document in the main petition
It was
to make it a chronological pagination? How will this pagination? Sir, is it required to be, sir, Mr. Ganesh?
Because these were
This
forming part of the main writ application as Annexure 1 and Annexure 8, Milords. And since
So we will color, we will tear it from additional affidavit and place it in the main application, then chronologically paginate ourselves.
Where is the writ rules of this?
That is what you want.
Let us see.
Yes, please.
The procedure of the pleadings and all, everything, I think the provision of the Code of Civil Procedure shall apply mutatis and mutandis. I believe.
Odisha High Court rules are also there.
Yes, there must be. Writ rules? Any chapter for the writ rules?
Chapter 6, Rule 27A.
Yes. Where is chapter 6? No, this is general rule for an affidavit. I just wanted relating to writ.
Applications and affidavit.
No, regarding this writ.
Writ.
Where? Is there any dedicated chapter? Because in other high court, there is a specific rules relating to a writ framed by the High Court. And there the rule 54 contemplates that the procedure or the pleadings shall be mutatis, it will apply. Which one? Chapter 15.
Application under Article 226.
Yes, 226, that should be.
Rules for issue of permits.
Yes. No, chapter 16. Chapter 16. Oh, this is relating to habeas corpus. Habeas corpus. Yes, rule 17. No, that is for the purpose of taking evidence. This is if you go by a strict rule of Rule 3, it says that the material documents referred to or relied upon in the applications shall also be filed along with the applications. If it must form part of the application, then by virtue of a separate affidavit, you cannot include it in the application itself. Then by virtue of an application, you'll have to include it in the application. Can it be done in this way?
We have to, in fact, file an IAS seeking for your.
Has to be.
Seeking for your lordship.
Has to be.
Include this as a part of the document.
And he is relying on
Yes,
as a preliminary objection,
An additional effort.
not by virtue of a simple affidavit.
It had to come by way of an application, as your lordship rightly pointed out. The rule also is there to that effect. So we should have filed an application seeking your lordship's liberty to allow us to add this as an addition.
Yeah. Very cumbersome or clumsy way of drafting so far as a declaration part is concerned. Mutually inconsistent declaration. You say, do hereby solemnly affirms that the facts stated in paragraph 1 to 6 of the additional affidavit, which you are affirming, in writ petitions are true to my knowledge. And the facts in paragraph 1 to 6, same, are correct and true to the best of my information, which I obtained from the records, which is correct. One is true to your knowledge, and one, the information derived from the record which you believe to be true. Both, same paragraphs. Two different way of affirmation. Anyhow, we are not going so technical. Yes. Now, once they have agreed to go for an appeal, according to you, they cannot exhaust the remedy, extraordinary remedy. This is your first objection. Can that be a fetter on their part in approaching the writ court?
161, as far as the 161 order is concerned, that is within the period of limitation, and 161 is appealable, Your Lordship. So
They are challenging the parent order.
they're challenging the show cause notice, Your Lordship, after even 161. They're challenging this initial show cause notice against which they have appeared. They have appeared in the
File reply, adjudication done.
Adjudication has done. In the adjudication, they have petition, adjudication has done, order has been passed. Pursuant to adjudication order, they have.
So they are challenging the order as well as the initiation of the proceeding also to be bad.
In 161, they have themselves written that without prejudice to the above, the applicant reserve its rights to file appeal pursuant to the rectified order passed by Your Honor as permitted by circular number so for other issues for which demand has been confirmed in the impugned order in original. Your Lordship, this liberty, they reserve their right in that rectification application. After passing of the rectification order, and in the rectification order, substantively, Your Lordship allowed.
So you mean to say this is clever drafting to overcome that 1074?
Exactly.
In effect, you are saying this.
Grateful, Your Lordship. That is so because Your Lordship, that is so because that appeal cannot be filed against.
Yes, yes, limitation point.
Your Lordship.
I understood.
And so far as the violation, Your Lordship, so far as the excessive beyond jurisdiction.
Where is that judgment of the Supreme Court which says that after the limitation period, the entertainment of the writ should not be encouraged?
Your GlaxoSmith claim. And Your Lordship has also by cognizing that order GlaxoSmith claim, passed one order, Your Lordship.
Yes. Mr. Kumi, you have to overcome this judgment.
My lord. My lord, I was apprehending this point will come. That is why in my compilation, my lord, the judgment of the Supreme Court in L. Chandrakumar I have included.
No, L. Chandrakumar is on a different note.
I'm coming to that, my lord. I'm coming to that.
That L. Chandrakumar says that so far as Article 226 is concerned, this being the basic structure of the Constitution by virtue of this Keshwanand Bharti's judgment.
That's correct.
That cannot be abridged, that cannot be curtailed, that cannot be taken away through a legislative fiat.
Very correct.
There is no doubt about it. But
no doubt about
there is two things, maintainability and the entertainability.
Very correct.
Proceeding may be maintainable, but may not be entertainable.
That's correct.
Here is, we are at the entertainable stage. Whether in a circuitous manner, you can bypass or overcome that particular rigor of the limitation.
My lord, I would say, if I could demonstrate that it is not circuitous one, but it is as per law, then my lord, I would say.
There is no difficulty. The law, as you know, the right is there, but in a more different way. Why I use the word circuitous manner means I did not say that remedy is not there, but the hidden or the latent intention, if it becomes patent, then why not the court should interfere?
Yes, my lord. I'm proceeding with making my submission with the things in my back of my mind that the approach of the petitioner probably is not straight or with clean hands, I would say. Let me submit on that, my lord. My lord, what happened when the order of adjudication dated 31st August 2024 was passed? That was passed on 31st August 2024. Within 90 days, I filed my application for rectification. That was filed on 22nd November 2024. Within 90 days, I filed. And when the order of rectification was passed on 9th of January 2025, I approached this Honorable Court on 8th of April 2025. So my first application against the 31st order of 31st August 2024, I approached the authority for rectification section 161 within 90 days, less than 90 days. It was expiring on 31st of 30th of November. I approached on 22nd.
And then second question, does the order of rectification or the provision of rectification, that order which is passed, will invite the doctrine of merger?
My lord, in my compilation, my lord, kindly see two judgments.
Or it is absolutely an independent exercise?
My lord, I would say, my lord, that if the provision is read in such a manner, then against the same so-called notice, two orders and two appeal. Merger is one concept, limitation is another concept. My submission is, on limitation, when it comes to limitation, the limitation will be reckoned from the date of rectified order. But when it comes
That
to
is why
merger,
then you are inviting a concept of a merger, that the original order passed by the authority, which is also amenable to be challenged by way of an appeal. But if the party have resorted to a rectification provision, then the order of rectification would invite the merger of the original order into a rectification order. And then if the appeal is filed against the order of rectification within the time, or if the writ is filed from the order of rectification within the limitation period, then the question of the entertainability does not arise. So one has to understand that whether this rectification provision invites the merger of the original order.
my lord, here my submission is twofold. Against the same so-called notice, if that is the understanding, my lord, if the law 107 is read in such a manner, then against the same so-called notice, there will be two appeals. That cannot be intensive legislature. Now, this is one submission. Another, my lord, the concept of merger.
I think appeal does not lie against the show cause notice. Appeal lies against the adjudication order which is passed by the authority. It is against the order the appeal lies.
There will be two orders and two appeals.
That's why I'm saying if there are two orders which are independent to each other, then there is no fetter on the part of the aggrieved person to file two different appeal. But if one order merges with another order, then there will be only one order operating in the field.
My lord,
and that if the appeal is filed against that, there is no problem.
My lord, my
I
submission
am
would be-
conscious.
My lord, submission would be limitation is to reckon from which point. That is the only issue. That is the only issue, my lord. Rectification order, rectified order will be the ultimate operative order, or there will be two operative orders. One, the order of 31st August, and also the order of 9 January. In the 9 January order, the amount has been redetermined. Entire grounds have been reproduced. Tax amount has been redetermined. And ultimately, the demand has been confirmed, considering the demand already raised in the 31st order and also the rectification. So ultimate liability is decided in the rectification order. So I would say, if one may say that the rectification order does not merge with the original order, in my case, some peculiarity is there. Entire demand that is part of the order dated 31st August is also part of the order dated 9 January. Kindly have a glimpse, my lord. So I would say there is a merger, and also the limitation will start from the date of rectified order. There are two judgments I would refer to, my lord. One of the Supreme Court and one of the single bench of the Karnataka High Court. Karnataka High Court has dealt with 161 GST under the same circumstances. My lord, if you lords would take the trouble to take the compilation, my lord.
Yes. Where is the compilation?
Lord, in that compilation, my lord, kindly see judgment of the.
There is a compilation which was given on the last day.
My lord, kindly see page 217.
Mr. Ganesh, you have extra?
Yes. Where is that? Then where it has gone?
That must be yours.
দুইটা দিয়েছিল তো না গোটা দিয়েছি ঠিক
My lord, kindly see.
ওইটা ফার্স্ট কপি
Madras High Court, my lord, single bench under GST section 161. It starts on page 217, my lord. And the 11 portions are, my lord, on page 219. Second para, page 219. The writ petitions have been filed challenging the order of assessment and order of rectification passed by the respondent pertaining the period so and so. Now, my lord, can you turn to page 220, para 5. At this juncture, the learned counsel for the petitioner would submit that the appellate authority would insist on calculating the period of limitation from the date when the original order, assessment order, was passed, and in such case, the appeal would be much beyond the period of limitation and would apprehend that the appeal would not be entertained as it is being made beyond the period of limitation. After assessment order has been made, Section 161 of the GST Act provides for an application to be made for rectification. Such rectification can be disposed either in favor of the assessee or against him. If any rectification is made as prayed for, the same would get merged into the original order. Just because the rectification application has been rejected, this period of limitation to challenge the original assessment order could not be said to begin from the date on which the original order was passed. It would only count from the date on which the order of rectification has been passed. In the present case, the original order of assessment was made on 7/8/2024 and the order of rectification was made on 12/11/24. Therefore, the limitation for challenging the order of assessment 7/8/2024 shall start ticking from the date of rejection of the rectification application from 12/11/2024. It is made clear that when the appeal is filed by the assessee as against the original order of assessment, the period of limitation shall be calculated from the date on which the rectification has been dismissed. So, my lord, this is on.
I think with all humility and the respect to my command, I think the basic fundamental principles has been overlooked.
My lord, then let us see Supreme Court judgment, my lord.
Yes, let us see.
Supreme Court, page 208, it starts.
Supreme Court judgment. Where is the Supreme Court judgment?
My lord, page 208.
208.
Hind Wire Industries Limited, Commissioner of Income Tax. My lord, the relevant portions are on page 210.
Yes.
Second para, my lord, third para, I would say, shortly stated. Shortly stated, the facts are that.
Just 1 minute. I have a very bad habit of reading the judgment from the beginning.
Sorry.
Just 1 minute.
My lord is there on page 210.
Yes, yes, that is what is that the order which sought to be amended means the rectified order.
My lord. My lord, now kindly see one circular of the board, CBEC, that clarifies the position more clearly, your lordship. If lordship kindly turn to page 201, and that is binding on the respondent, opposed parties. Page 201 is the circular that starts, and the relevant portions are, my lord, on page 203.
Yes,
Para 3.5,
yes.
where order under section 73 or 74. My lord, I pause for a while. Our case is 73, where order under 73 or 74 of CGST Act has been issued, but no appeal against the said order has been filed with the appellate authority, or where the order under section 107 or 108 of the CGST Act has been issued by the appellate authority or the division authority, but no appeal against the said order has been filed with the appellate authority. In such cases, where any order under 73 or 74 or 107, 108 of CGST Act
So
has
he
been
says
issued.
that if no appeal is filed, that he has a right to file an application for rectification.
Yes, then can turn to my lord page 204, 3.5.5. Further, it is to be noted that in cases where an rectification has been made by the proper officer,
So it
in the
can be,
order,
an appeal may be filed under section 107 or 112, whatever.
that's right, my lord. So my submission is that for the purpose of reckoning the limitation, for the purpose of reckoning the limitation,
Correct. I have seen from the rectified order.
Such rectified.
So that means the rectified order is amenable to be challenged by way of an appeal under section 107
that's right. Now, my lord,
or 112.
107.
107
Mr. Purve, that word such, that is significant. The word such rectified order.
yes,
That is-
rectified order, my lord.
that
Such
is-
rectified order.
That is significant.
My lord, let me read that again. Further, it is to be noted that
No. What you wanted to say is that by taking an analogy of the Supreme Court judgment and then the circular, you wanted to say that so far as the limitation point is concerned, it will start from the day when the rectified order is passed.
that's right, my lord.
And this circular talks about that the rectified order is amenable to be challenged by way of an appeal under section 107.
Correct, my lord.
It is not necessary that I should challenge the original order.
That's right, my lord.
This is what you wanted to say. And if the writ petition is filed within the period of limitation for filing an appeal, then in that event, the plea that the writ should not be entertained on that count may not arise.
My lord.
This is what you really wanted to say.
My lord. My lord, just one line I would say more, your lordship. One line. If your lordship would see the impugned order dated 9/1/2025, what has happened in that impugned order, the entire 15
No,
grounds.
I understand. According to you, this rectification was not restricted, where the authority have reopened the entire thing and have revisited the order and restated or reiterated the orders on some count, and in some count he has already rectified the demand.
And then redetermined. So, my lord, I would say when the grounds of challenge and the demand and the grounds on which the demand is confirmed in the both.
So according to you, the scope of rectification is only to correct the ministerial error or the error which is of, I would say, the human error, not the actual decision. Then it has to go back to the authority to decide.
In this case, the peculiarity is
can he revisit the order in the guise of a rectification?
No, my lord. What has happened in this case? Why this rectification at all came?
Like an appellate authority, and then reiterating that every demands are.
Mr. Kurmi, tell me one thing, that rectification application, whatever you wanted to rectify, that is allowed.
That is allowed.
You are not agreed by rectification order. Make it clear.
I was agreed by the redetermination of the amount.
Mr. Kurmi, can you clarify our doubt that whatever your application for rectification contained, that was allowed, and you are not agreed by that order of allowance of your application for rectification?
That's right, my lord.
Confine it.
That's right. But the thing is that, my lord, I cannot.
Are you agreed, sir? Only one simple question, sir. Are you agreed by the order passed on your application for rectification, which is allowed in toto?
My lord, the impugned order, rectified order, also considers the portion against which I am aggrieved.
True. So I understand that your rectification say was filed on 5 grounds. Let us hypothetically understood, and the authority have allowed the rectification application by rectifying on 2 grounds. So you are still aggrieved for rejection of the other 3 grounds. That is what you want to say? No, I believe no, because your rectification was restricted on a particular score, not the whole of the order.
Point
but
was,
the grievance is that he has revisited on all the grounds, on everything, and restated or reaffirmed the observations or the order of the past in the original order, and therefore it is really a reassessment order.
My lord, yes, my lord, let me summarize my arguments, your lordship, in 2 lines, just 2 lines. My lord, my submission is that.
So it's better the authority who have understood, who was exercising the jurisdiction of the rectification, actually committed an error of going into the nuances of the others. He should restrict the ground on that, and therefore let us set aside and send it back to the authority to consider the rectification application afresh on that ground. Strictly on the grounds which is there.
Without going into
the other aspect, for which he has not raised any ground thought for rectification. So we are sending it back.
My lord, my submission, my lord, okay, my lord, in the post lunch, my lord.
We'll send it back.
My lord, post lunch, may I be allowed to submit for 5 minutes more?
Yes.
Post lunch, my lord.
Yes, please.
My lord.
Yes.
May I please, lordship? My lord, pre-lunch, your lordship, what failed from my lords, that my application for rectification was one point, and that point is allowed. So how I am aggrieved? And if not so, then my lord, the other points which are part of the rectification order.
Original, that was for which no rectification was sought. Whether the authority can go into those aspects and reassess that or redetermine that, that
My
is
lord.
not permissible.
My lord, let me
So
submit on that,
take
my
the
lord.
order in that sense and we'll
My lord.
put it back. No difficulty, sir.
My lord, my only submission is that
Yes.
reckoning of limitation is coming on my way. Limitation should be counted for the first order from the date of passing the first order or from the date of passing the rectification order.
Don't worry, we are not going into that aspect. What we will say that your grievance is that the officer or authority, while considering an application for rectification, which was really aimed at only one point, cannot redetermine or revisit the other points.
That is not my
He has
grievance.
exceeded his jurisdiction.
My submission is that the limitation for computation of 107 people 90 days period.
Oh, no, understand. I understand. We will be then taking this plea that can he, in exercise of the power of rectification, can he revisit the or other portion of the original order?
My lord, my only submission is that my limitation is coming on my way. The first order I applied.
We are not going into limitation. We are going into that aspect. Don't worry.
My lord,
We are
then
not
my
going
other
into
point-
limitation. We are going into that aspect.
My lord,
Let us see.
the other grounds, my lord, the other grounds which I am challenging, that ground will remain unanswered, your lordship. Then I must be given liberty to file appeal. My lord, circular of the board, just I was reading, my lord, kindly have a glimpse of that, page 204.
That's true.
My lord, kindly see page 204, circular of the board.
Impressing upon him.
Absolutely.
Since now, and he has been saying this.
My lord, kindly see page 204. Whether I am delayed in approaching this court.
You are not. So far as the rectified order is concerned, you are not. But
I am saying, my lord, even the
but
original
we
order,
say
I am not delayed, my
that we
lord.
find can an authority revisit this order for which no rectification was sought?
My lord, my submission is that the rectifying authority can consider the points because ultimately he has to determine the final amount. Ultimately, he has to determine the final tax liability. That is why he has to take into consideration all of them and redetermine the tax amount. My lord, kindly see. My lord, kindly allow me 5 minutes more. My lord, kindly allow me 5 minutes more, my lord. My lord, kindly allow me for 5 minutes more. Kindly have, my lord, page 204. The circular of the board. Kindly have it, my lord. Kindly have it, my lord.
Yeah.
Page 204.
Yeah.
Paragraph 3.5.5.
Yes.
What fell from my lordship that my application was limited to one ground and that is allowed. Then
Yes.
what next, my lord? What next? Should I file an appeal against the original order or the rectified order? Is dealing with that, your lordship. Para 3.5.5 of the circular
Yes.
issued by the
Yes.
CBSE, which is binding on the respondent. Further, it is to be noted that in cases where any rectification has been made by the proper officer in the order for which the rectification application has been filed. So I'll pause for a while. Rectification application was filed and rectification is made. Then what next, my lord? An appeal against such rectified order can be filed.
By whom? By whom?
By me, my lord.
Can you? If your rectification application is allowed, are you in person aggrieved?
Meaning thereby that in the
Then-
rectification order, in the assessment of tax, the entire amount has to be brought at one place, the rectification has to be made, and the tax has to be redetermined.
Sir,
That was
I am
what exactly he has done.
thinking. I'm really in fix. How to understand the thing. You have a right to file a rectification application. If flagging an issue to the authority that these are the points, say A, B, C, D, where you have committed a wrong or error has come, and the authority found that A, B, C, D are correct. There is a error and rectified the order. Can you challenge, say, E, F, G, H, which was not sought for, any rectification was sought for, against an order rectifying the original order on A, B, C, D? I'm asking.
My submission is that in case of a tax assessment, when the order is rectified, then he has to redetermine the whole tax liability. That is what he has exactly done, and I would say he has rightly done so. My lord,
No,
the
this
tax
reassessment, Mr. Kurmi, let me understand. The reassessment is done after accepting that there has been an error. Say a person is charged on 7 multiple grounds, A, B, C, D, E, F, G. Rectification is sought on ground of A, B, C, D, and if the authority found that this is an error, then whatever the amount which is charged on A, B, C, D, that has to be varied. He has to deduct those amounts from the total
Correct, my lord.
amount.
Then
It does
ultimately
not mean that the authority has also entered into the FGHI.
My lord, then in that case, I would say there is a judgment of the Karnataka High Court or Madras High Court that I read, your lordship, meaning thereby that I was.
That is a single bench judgment. It is not binding on the division bench.
My lord, I am just showing my bona fide that I was having a bona fide impression that against the rectified order, an appeal would lie, and also I can file a petition.
No, definitely. Provided you are a person aggrieved. The very basic fundamental first principles of law is that a right of appeal is available to a person aggrieved by an order. If a person who is successful in getting the order, then can he be termed as an aggrieved person? I'm just asking this.
That's true, my lord.
So,
my lord, I would say
you are not an aggrieved person because your rectification was allowed.
That comes point. That is a point of merger. My lord is saying that is a point of merger. I am on the reckoning of limitation. I am saying the limitation should be reckoned from which date. That is what
definitely from a I can understand, sir. Suppose if you have asked for a rectification, say on all the grounds on which you have been charged, and then the rectification is allowed on some of the grounds. That means the authority have refused or declined to allow that rectification on other grounds. You have definitely a right of appeal, or you can challenge in a whatever manner so far as the rest the grounds are concerned which has not been rectified by him. You can. There is no confusion in our mind. But if the rectification is on one point, which has been allowed, is still the right of appeal would remain. I am in fix.
My lord, then we are simply referring to the point of limitation wherefrom it has to be reckoned. My lord, for the sake of argument, I would say, even if the limitation for 31st August order would have started from that day, then my lord, I am bona fidely and diligently pursuing remedy. First, I filed the rectification application, then I approach this honorable court. So, meaning thereby that, then if at all matter goes back, then the period lost in pursuing remedy bona fidely by me should be excluded, my lord. That liberty must be given.
That is the law. If section 14's advantage can be taken by you, I do not know whether
that liberty I may be given, my lord. That liberty I may be given.
We will not say anything on that.
My lord, my MP still Supreme Court judgment is directly on the point. My friend is there, he will place your lordship before his lordship. From the day the initial order was passed, even if ultimately the proceeding is aborted, then the entire period has to be excluded.
That is what is there. If you are entitled under the law, then why liberty is granted? You are entitled under the law.
Because my lord,
authority will consider.
To alleviate any confusion, just
no. There is no confusion in their mind.
My lord, the period.
There is no confusion.
Period from the date of
that is permissible in law. It will be. Where is the difficulty?
My
Mr.
section
Kurmi, why should
107 will
we
come on my
go
way.
into, Mr.
Section
Kurmi,
1.
Mr. Kurmi, why should we go into that limitation aspect at this stage? When you
My lord, otherwise I will have
want
no
to,
remedy. I
want
will
to
be
go in
remedialist,
for,
my lord. The authority.
you want to avail the opportunity of alternative remedy, why should we go into that? The appellate authority is is the competent authority to decide that.
There is a factor in
Whether section 14 will attract or not attract, or whether.
there is a factor in the power of the appellate authority, my lord. He knows that I can grant extended period of 30 days more, nothing more than that. But unless my lord shows some indulgence, it is not that I did not follow the proceeding bona fide. I followed the entire thing in bona fide, my lord. I filed the rectification application in time. I came to this court with the time. Now it is all carrying a bona fide impression. Judgments are there.
Why convince the authority? There is no difficulty because the power of the section 14 does not empower or does not contemplate condonation. The section 14 says that those period would be excluded from the purview of computation of the limitation.
My lord, that liberty I will be given at least.
That is the section itself.
My lord, I have pursued the
That
proceeding.
is the section itself.
There is no negligence on my part. What I understood, what impression I got from different judgments, that I have done. So it is not a case of negligence or inaction on by part.
This section 14 does not talk about negligence, sir. Language, if you look at it, never uses the word negligence.
My lord, the court has read
It simply says that a person has bona fidely proceeded before a wrong forum to pursue the remedy in a good faith, and then he has approached the right forum. Those period where he was pursuing his remedy shall be excluded. I think that is a language. It should be excluded.
Limitation.
Yes,
Limitation Act.
MP Supreme Court judgment, my lord. Para 40.
Sir, the judgment cannot override the section. So one has to read the section.
Court has analyzed 14.
Yes. And it says that shall be excluded, means that it will not be taken into account for the purpose of computation of the period.
My lord, that may be indicated in the order, my lord. Otherwise, I will have difficulty before the authorities. I will be remediless. I will nowhere. Pursuing remedy bona fidely, my lord, I will be thrown out of the this thing, my lord. At least that right of mine is protected. Because, my lord, I am before your lordship, not on any circuitous manner. I have straight away come to the authority, file my rectification application, and there is circular of the board.
No, it's card. What is that?
That liberty may be granted to me, my lord, to file appeal.
Liberty may not be granted, your lordship. Why, your lordship?
It's our discretion.
Your lordship.
Why you are interfering?
Your lordship, why I am worried, your lordship? Tomorrow everybody will come.
Whether to grant or not to grant, that's our discretion.
If alternative remedy, that's all.
Your lordship. Lordship, why I am worried, your lordship?
Any observation made at this stage is preposterous. Why should you argue that arena which is not warranted?
Your lordship, grateful.
Yes, that's all. Yes.
My lord, I've had lot to submit on merit, your lordship.
Yes.
I had lot to submit on merit, your lordship.
Now, once you have stated that you will approach, you will avail the opportunity of alternative remedy, then why should we go into that?
No, my submission was that if my lord is relegating me back to the alternative
Just 1
remedy.
minute, Mr. Kotli, 1 minute. Yes,
Madam, that liberty may be granted to me at least.
let us see.
My lord.
Yes,
Grateful.
dictate. I will dictate.
Deeply obliged, my lord.
Just after rising.
At 6 to 2 p.m. I don't know.
There are 5 matters, out of which the first matter, that is WPC 19172, and the item WPC 20026 of 2025. In both these cases, we are filing the counter affidavit. We have already filed and serving copy.
What is this matter? 45?
Lord, this is a mines and minerals matter, Lord. If with the Lordship's indulgence, I appear digitally in the first matter. This pertains, Lord, to the validity of Rule 12 capital A of the Mineral Concession Rules 2016.
Okay. So the virus is under challenge.
Yes, please.
Yes.
That is to be
So this, we have received the counter affidavit today only, Lord. In fact, just in the court.
You have served the counter affidavit upon them. They have received today, they are saying.
Just in the court, my lord,
So
today.
far as state is concerned, my lord, we are filing the counter affidavit, already filed, serving copy right now, my lord, today.
In what matter? In the first matter?
In the first matter, and the sub-item, that is WPC 20026 of 2021. Ghanshyam Mishra.
My cognate matter, Lord, for the fourth year, second year, so 2 different years, 2 writ petitions.
Oh, 2 different years.
Yes.
So in the second matter, they have not filed a counter affidavit, but I believe, Lord, the one counter should be sufficient.
So,
but our counter, so far as state's action is concerned, but once the virus is challenged, the union has to respond, my lord. But the rules.
So who is representing the union?
Yes.
Kindly give us just 10 days time, Lord. We'll file a rejoinder, my Lord, then your Lordship.
No, that will definitely give. We are just inquiring whether this Union of India central government is represented, because the virus of the Central Act is.
They are supposed to file a counter.
They are supposed to file the counter.
So, but they are not represented. Now they are not appearing.
The Union Council is served, well, they have not filed counter.
But they are not, even on a virtual mode, they are not here. Anybody is there? On a virtual mode?
No, because opposite party number 5. I think their names are not. Yes,
5 is the state.
It is there. It is there. 5215. They have.
The 2 to 5 are all state government. 1 is Union of India.
Mr. Pari?
Mr. Pari is, where is he? Mr. Pari, Mr. Kashyap and Mr. Panda.
But
None of them are.
apparently they have not filed counter.
So then we can proceed whatever is there on the pleadings. Now, I think the senior advocate wanted to file a rejoinder. That is his right to deal with those.
In one,
So kindly give us 10 days time, Lord, when.
issue 5115, I'm appealing for the petition.
Yes, you have been. So are you using this particular counter in all the matters?
No,
Why?
counters have to required to be filed, because if you
When you will file?
other matters, only notices were issued on 11/8 and 14/8. This may grant us 3 weeks time so that we will file.
No, when the virus of the act is challenged, I think your stand to the same would be the uniform in all the matters.
Demand notice, it is pursuant to the statutory provisions, which is the subject matter of challenge.
Whatever. Mr. Pari, now you have come, sir. Do you like to, because the state has filed this counter. Please unmute your system, Mr. Pari.
Yes, my lord. May I audible?
Yes.
Yes. My lord, in this case, we have not received, as yet not received any instruction from the government as regard to the challenging the virus is concerned. So I need more time, my lord.
What are you saying? How much time you require? Because on all the occasions you are asking for an adjournment instruction.
We have taken 2 occasions. We have taken time. Admittedly.
So.
Okay. One.
And the matter is of a importance when the provision is under challenge.
Yes, my lord. I know that I have taken twice I have taken time. last chance may be given. Accordingly, I try to get
Because
it.
the state has filed the objection, but a counter, but so far as the
I didn't receive the
central
same.
government you are
I'll collect
representing,
this.
they have not filed.
May I add, Malas, in my matter also, which my lords were kind enough to hear a few days ago. No reply has come. I am the last matter in 45 item. The writ number is 22431 of 25.
Yes.
Your lordship were kind enough to hear it, Malas, and this also no reply has come.
Tata still.
Yes, I have
Tata
seen, I have
Steel.
seen that. So all these matters where the virus is there, then can you have a different stand? The state cannot have a different stand on that.
State cannot, because state has raised the demand basing on the statutory provisions. So we have filed our counters that is confined only to the demand. But so far as the statutory provisions, that has to be
Mr.
responsible.
DSG, we can't continue adjourning the matter for all time to come. There must be some.
I apologize for this, my lord, but twice I've been telling you one more chance may be given. After vacation, any date, let's may fix then in the meanwhile.
I have a small submission here. State is yet to file counter in my matter. I am also challenging virus and demand separately. State is to file counter in my matter also. Subject to the state says that
same in all the matters, but
so if they say that they will adopt the counter here, then we will only insist upon the
facts are a little bit different, demands are different.
That's right.
So
That's right.
What I'm praying, my lord, though, in whichever matter the state has filed the counter, let the serve copies to me, and I'll try my best to get it all the instruction by next week. Next day.
No, instruction will not do, Mr.
I know
DSG.
this challenge. The
If
virus
you
is
do
one
not
part.
file your pleading, then we'll have to proceed on the basis of what is there on record.
Well, but one chance, I'm just giving. Twice I've taken time, let me tell you what I wrote a letter. Anyhow, my lord, once last chance may be given then.
What is this? The state has filed the counter affidavit.
Given the allegation of the petitioner, there's a violation of section 6(2)(b) of the PGST Act. Allegation, my lord, is there's a violation of section 6(2)(b), where, my lord, the state for the same period, for the same amount, has already assessed us. Matters are pending in appeal, and we had approached this honorable court in absence of the GST tribunal. And as per the orders of this honorable court, we have already paid another 10%, and the matter is kept pending till the formation of the tribunal. In the interregnum, what happens, my lord? The CGST authorities, they pick up the same issue, my lord, and they passed, in spite of my repeated requests and also my reply to the show cause, that this matter has already been assessed by the state authorities. They proceed and they finalize the matter and they pass an order in original, which is impugned before the lordship.
For the same period.
For the same period, for the
There was some I think the prohibition, or there was some prohibitory provision. It says that it cannot. If one authority has done, then the other cannot. I believe.
That is the language of section 6(2)(b). On the last occasion, your lordship had raised the pertinent question. The language of section 6(2)(b) is proceeding initiative.
So who has initiated the proceeding
The
first?
proceeding was initiated by the state authorities first.
First.
Because on the basis, because there was a report from the DGCI, it was sent to the state authorities. Basing on that report, my lord, they have initiated the proceeding and they have completed all. Now, my lords, your lordships on the last occasion, my lords, had raised
GST. Yes.
Had raised, my lord, a question which I was supposed to answer, that what would be the purport and the meaning of the word has initiated any proceeding on the subject matter. The lordship kindly turn to section 6(2) subclause B.
What is the definition of a proper officer?
Proper officer, my lord, has to be declared by the state authorities. They have declared that all officers from investigation till adjudication are proper officers.
No. Proper officer under section 291, 2 subsection 91 is in relation to any function to be performed under this act, means commissioner or the officer of the central tax who is assigned that function by the commissioner in the board.
Well, that dispute in the present case is not there, because what has happened in this particular case. In fact, the order, Lord, has been passed by the proper officer. So far as the CGST authorities are.
No, I am thinking in a different. That day, my mind did not. That was a different consideration. Now, with a fresh mind, something more may come. So I'm just looking at the provision of section 6(2)(b).
You know, admittedly,
there are this word proper officer, the expression are used twice. I was just trying to figure out that when it is used in two places, what does it mean?
Where a proper officer under the State Goods and Service Tax Act or the Union Territory or and Service Tax Act has initiated any proceeding on a subject matter, no proceeding shall be initiated by the proper officer under this act on the side.
No, that is where the twice the proper officer is used. So one has to find out what does it convey.
Understanding the orders, there are hierarchy of officers. So far as the state is concerned, the officers investigating can also complete the assessment law because they are declared as proper officers for carrying out investigation or carrying out further proceeding under the act.
No, I was just maybe a very improper, may I say, I'm not using the word foolish way of consideration, but improper way of consideration. So I was, can it convey this meaning or I am wrong?
No.
And I wish to be wrong.
No.
I wish to be wrong. I'm just putting that impression. If you read B, please.
Where a proper.
I'm reading.
No.
With me, you read.
Where
A proper officer under what?
Under
the
the
State Goods and Service Tax
Your Lordship,
Act.
just pause for a moment.
So proper officer under the
Declare-
State Goods,
Laws.
just wait, State Goods and such, or Union Territory Goods or Services Acts. So there may be a proper officer who is to deal with the State Goods and Services Tax Act. And another proper officer who is to deal with the Union Territory Goods and Services Tax Act. So these are the two
officers.
Now, when you say has initiated any proceeding on a subject matter, so one can understand either the proper officer under the state GST or a proper officer under the CGST. If he has initiated any proceeding, then no proceeding shall be initiated by a proper officer under this act on the same subject matter. Now, does it mean the same proper officer of the SGST or a proper officer of the CGST?
Because your Lordship would appreciate, there's a cross empowerment.
Can it not be said that if he has concluded at one point of time, say the proper officer of the state GST, if he has concluded, then it is the proper officer of the state GST who cannot initiate a fresh proceeding on the same
With
subject.
great respect, no. Because in cross empowerment law, a particular report, investigation report, can either be initiated and completed by the state authorities or by the central authorities. So if, my lord, the purpose of this, my lord, provision, if I have understood it correctly, now if the state authorities have initiated and completed a proceeding,
Then it overruled the central authorities.
because that will be a double-
Because the state authority is not only deciding the state GST, but also the
central part of it. So the-
Overlapping.
So here, my lords, in this cross empowerment laws, if the state officer begins and completes. it's
I understood. After reading, that's why I used these two expressions, inappropriate and foolish.
No, not at all, not at all. So it does not mean that a proper officer of the state, if it completes, will not be open to only the proper officer of the state. So, but it will be the
I
proper
understand.
officer.
That's why I was thinking of or, and then the proper officer cannot initiate. That's why I'm just saying under this act.
Under this.
This is what I wanted. Anyhow, yes.
Now this matter stands.
So now has initiated. So if the state has initiated
And completed.
earlier, then according to you, the central proper officer under the CGST cannot for the same subject
matter. And this matter, my lord, I'm grateful to your lordship because this matter was adjourned on the 14th of last month. And on the very same day, my lord, the Honorable Supreme Court, dealing with the same issue, they have found, my lord, ruled what is the proceeding initiated and what is the subject meaning of subject matter. And if your lordship would permit me, my lord, your lordship would see the judgment of the Honorable Supreme Court, lords. Here,
Confirm that Gujarat High Court judgment, GK trading.
Yes, they have confirmed the Allahabad High Court order, my lord. And if the lordship would just see the.
This is Armor Security India Limited.
The lordship may kindly turn to page 1. They have brought out an index. From there, the analysis would be that whether the issuance of summons can be regarded as initiation, which was your lordship's query on the last occasion. Initiation of proceeding within the meaning of section 6(2)(b) of the CGST Act. The second issue was whether, this was also your lordship's query, whether subject matter within the meaning of section 6(2)(b) of the CGST Act includes all matters dealt with in summons under the Act. Where then the third one was the purport of the order. There the Honorable Supreme Court has held, the law, issuance of summons is not the beginning of the initiation of a proceeding. They have, my lord, so far as GK Trading of the Allahabad High Court, which I have given you on the last occasion, they have said that this falls within the arena of investigation. The proceeding begins with the issuance of a show cause where the department, my lords, decides
contemplated to impose
or
the tax.
impose this tax by either following the provisions of Section 73 or
Whatever.
So that was what was
That is what is the impression.
my lord. And that in fact has been held because the lordship had raised whether the issuance of summons would be the initiation of the proceeding, because in this particular case, the initial summons was issued by the CGST authority. And after the investigation, the report was sent to the state authority. Basing on that report, the
show cause notice was issued.
And the proceeding was completed. Appeals were confirmed. I came before.
Where is the portion?
Which one? No, the lordship may kindly see.
No, which portion is the first answer?
No, the first answer your lordship would kindly see. Page 42, paragraph 54. Before, may I just please, before addressing what constitutes proceeding under Section 62B of the CGST Act, it is apposite to first consider the petitioner's contention that the phrase any proceeding is intended to encompass all proceedings initiated under the relevant GST enactment. We may reproduce the provisions as discussed. Your Lordship, I'll just
no difficulty, yes.
Section 62B of the CGST Act precludes a proper officer under the CGST Act to initiate any proceeding on a subject matter if a proper officer under the SGST or the UGST Act has initiated any proceedings on the same subject matter. The CGST Act does not define the term proceeding. In context of this provision, the chairman of the 11th GST Council meeting held on 4/3/2017, while discussing the approval of the draft Central Goods and Service Tax Law, opined that there should be an express or implied bar to prevent a taxpayer from being subjected to proceedings before multiple officers for the self-dispute. Section 70 of the CGST Act empowers a proper officer to summon any person whose presence is considered necessary for giving evidence or producing documents or any other relevant materials in an inquiry. The issuance of summons is one of the instruments.
57 is a summon is not a culmination.
Culmination of an investigation, but merely a step in its course. It is in this context that the legislature has used the term inquiry in Section 70 as at the stage of issuing a summons, the department is primarily engaged in gathering information regarding a possible contravention of law, which may subsequently form the basis for proceedings against an assessee. Since the objective is to collect information, the department has, in certain instances, advised resorting to a letter of requisition in place of a formal summons. At this stage of issuing summons, the department is yet to determine whether the proceedings should be initiated against the assessee. Such evidence gathering and inquiry do not constitute proceedings within the meaning of Section 62B of the CGST Act. The mere issuance of a summons cannot be equated with proceedings barred under the Act, as the subject matter cannot be ascertained solely through summons. The said summons should not be issued in routine matters or for documents readily available on the GST portal. They ought to be issued after much thought and consideration as to the exact information required. We acknowledge that the issuance of multiple cyclostyle summons may indicate a roving inquiry. Then a lot you could come to paragraph 59. We affirm and appreciate the view taken by the High Court of Allahabad and GK Trading Supra. They have referred to GK Trading earlier notes, and the High Court of Kerala in KT Saidala Levy Supra respectively. The High Court of Allahabad rightly held that the issuance of summons cannot be conflated with a statutory step taken upon conclusion of an inquiry. Similarly, the High Court Kerala was correct in holding that initiation of inquiry or the issuance of summons does not amount to initiation of any proceedings. The phrase initiation of any proceedings refers specifically to the issuance of a notice under the relevant portions of the GST enactment. At this juncture, we may wish to refer to the guidelines of issuance of summons under Section 70 of the CGST Act issued by the Central Board of Indirect Taxes and Customs, GST Investigation Wing, dated 17/8/2022. In view of the facts of the present case in hand, we would like to inject thrust into the guidelines dated 17/8.
62 is to be, yes, 62 is to be also.
Then the Lordship may come to paragraph 62. I'm obliged to note. The High Court correctly held that the term any proceedings does not encompass summons issued pursuant to a search or investigation, as at that stage of issuance of summons, the department is merely engaged in gathering information. We are in agreement with the finding that in case of search is clearly distinct and separate from proceedings initiated only after issuance of the show cause notice. Then your Lordship may say, then we may now proceed to elaborate on our understanding of initiation of any proceedings. Then they follow Ramnath Ayer's, then they follow Black's dictionary below. And then your Lordship may kindly come
66.
66 notes. A show cause notice sets the law in motion concerning the liability under the statute containing charges that a specific person is called upon to answer. In other words, it sets out the alleged violations of the legal provisions and requires the assessee to explain why the duty should not be recovered from them. Thus, a show cause notice cannot be vague, nor can any allegations be made without evidence being commensurate with the gravity of the charges levied against the noticee. It sets forth the framework for the proceedings proposed to be undertaken and provides the noticee with an opportunity to submit the explanation before the adjudicating authority. It outlines the background for the initiation of such proceedings, whether arising from an audit of accounts by an internal audit wing, scrutiny of returns, or intelligence gathered by officers of the Audit and Intelligence Commission. It is further mandated that the authority issuing the notice must meticulously set out all relevant legal provisions.
That's true. Section 6, paragraph 69 is a flow chart.
Is a flow chart now. That is what I was going to.
Yes, yes. They say that under what circumstances and when the occasion to issue a show cause arise.
Then your Lordship may kindly come to paragraph 74 at page 49. Lordship, or at page 49.
74 paragraph.
74. In the
already read.
I'm grateful notes. I'm grateful notes.
And also paragraph 70.
I'm told, my Lord, I'm told John F. Kennedy, my Lord, was the fastest person with some 240. Of course, I'm not citing Vivekananda, my Lord, but he was the fastest person with 248 words per minute with full understanding.
Don't.
No, sir. Paragraph 74, your Lordship have already read. I need not bother your Lordship. Now, your Lordship may come to paragraph 79, you know, that's page 52. What? Your Lordship? Paragraph 79.
Yes.
What? 79. That page
Yes, I'm in 78 because I go serially. So that's why.
I'm sorry.
Don't worry.
I'm sorry. I'm sorry.
Stress is on subject matter.
Yes.
If your Lordship are through with 78, 79 says, what emerges from the foregoing discussion is the implicit understanding that the subject matter in question pertains to the determination of tax liability referred to as dispute.
Avoidance of conflicting determination and the jurisdictional overlap. This is what it says. It ensures.
Again, they have referred to GK trading laws.
Yes.
Then they have referred to whole
Satyam casting.
Satyam casting, and also Orissa High Court laws. Then the laws, your Lordship, just skip it over. The Lordship would kindly turn to page 57, paragraph 86. Page 86, page 57 at paragraph 86. The expression subject matter contemplates proceedings You notice that then speak. In 86, paragraph 86 and 87. In the elections, we speedily come to the conclusion.
So it is clarified even where there is slightest overlap in the text like.
In the logically skip the other portion where they have defined what is an order passed and all that. The logic at page 61, paragraph 96 is the conclusion. Page.
No, understand. So you
then,
just.
Then what I wanted to try to point out is observation H. They say that if it is found that the authorities are not complying with these aforementioned guidelines, it is open to the taxable person to file a writ petition before the concerned High Court under Article 226 of the Constitution of India. That's at page 65. And in this present case, my lord, pursuant to the show cause notice, I have, my lord, intimated the CGST authorities that I have already been assessed. And
Yes.
here, my lord, the facts of the present case, my lord, would be that first, a show cause notice was issued by the SGST authorities, consequent upon receipt of an information from the state authorities. And that was, my lord, the first show cause notice was 2/7/2021.
Only the dates have to be relevant. Only the
At
dates
page
have to be
44,
relevant.
So far as SGST authorities are concerned, the first show cause notice is 2/7/2021.
Yes.
That's at page 44 of the writ petition, if the lordship would kindly. If you look,
What is this?
a small date chart.
In this case, I am with my Lord and Senior, Mr. I'm appearing on behalf of the state. Under what circumstances we have completed the assessment, basing on the DGJ letter. Your Lordship may for a moment, so now the actual aspect is concerned. Your Lordship for a moment may kindly look into
That is small
that
date chart by
letter.
lordship's convenience.
The DGGA has given us liberty, direction, given us that you complete the proceeding. So accordingly, we have completed the proceeding, Your Lordship. And also,
So the question is not completion of the proceeding. The question would be initiation of the proceeding.
sorry, we have initiated first.
So
We have
the thing
completed
is that
first.
you were permitted to initiate the proceeding. If that impression can be gathered therefrom, then it means that the state GST authority, the officer has initiated the proceeding.
Your Lordship.
And therefore, by virtue of this section 6(2)(b),
Your Lordship.
the central under the CGST, the proper officer cannot
Your Lordship.
initiate
Your Lordship.
proceeding on the same subject matter, means for the same period.
Their central GST argument is that they have initiated the
By virtue of a summons having issued upon them. Now the Supreme Court has gone against them.
And the Supreme
Court,
the summons lord by the central authorities was, I've just prepared a small date chart for lordship's convenience.
One
That was 30.
30.
30, my lord, I get, my lord, the first show cause from the state authorities on 2/7/2021. And the last show cause on 30th of July 2021. The CGST authorities, they give the show cause notice on 13th of August 2021. If your lordship would kindly see, my lords. I prepared a small
30th of July was the first so cause notice. 2nd July.
2nd July. Then the second, my lord, notice was on 30th. The third notice also was on 30th. The CGST authorities, they issue a notice, show cause notice on 30th of August 2021. So at a prior point of time, my lord, the SGST authorities had initiated the proceeding.
Got your point. We need these two after this judgment. What more?
I bought on those.
So we need those judgments.
And so
Lordship, we issued the notice on 13/8/2021.
But before
And-
that, the
and-
SOCOS was already issued by the SGST,
SGST
proper
has
officer.
issued As per my.
2nd of July and 30th of July. These are the two dates where two SCNs are issued. And prior thereto also.
1718 and 1819.
Yeah.
1718 and 1819.
December.
Two notices. GST DRC 018.
So only two SOCOS notice, not three.
Because the period.
A third one is by central.
No. So far, the period, my lord, is 1718, period is December 2008, 17. The third one is, my lord, 1819, from March to April.
So the two SOCOS notice on the same day.
On the same day.
That is 30th July.
30th July.
Okay.
Because there are three periods involved.
Okay. Yes.
So page 89 is CGST.
Page 89 is
Now what do you say after this judgment has stared at your face?
Judgment.
and
Actually, I was countering to the summon which was first issued on 24/5.
But now the court has held the summon is not the initiation.
And to my knowledge, we have issued notice on 13/8/2021.
That is what he admits.
And that is as per department information, they have given that the State Department has issued notice on 28/2/2022. I had
No.
on that only.
2nd of July and 30th of July.
That you're going to get it at page 44, page 60, and page 77. And the next one of those notices. So far the state authorities are concerned.
So, sir, what remained after this judgment? Nothing.
And the Honorable Supreme Court has said that that other one has to be quashed in the conclusion.
Once we have
Your
issued the
notices
notice,
are under
we have passed our
73.
They were then had to
74.
go. This
74.
was absolutely, I would say, debarred. The jurisdiction of the authority was barred or was taken away.
Lordship, once we have issued a notice, we have passed an order as per section 74(9) and 10. We have passed our order because we have issued a notice that has not been ever challenged before the High Court or anywhere.
Your Lordship,
So we have passed that order, Your Lordship.
So what?
That's my conclusion.
And now the order is under
That
challenge.
order has been,
No.
and we were.
And if they challenge the very root of the initiation of the proceeding, then definitely
The summon, we were challenging to the summon is to be there.
not
Now
necessary.
that it has been clarified by the Supreme Court.
What there remains nothing on that. Yes. Nothing
Sir,
you are
this
supporting.
page numbers, I think, some numbers. Serial number 6 and 7.
I'll check up and make the necessary clarification. So what we have page
2721.
Page 44, 60, and 77 was.
That I think is not
It's page
matching.
44, 60, 77 is not there.
44, it
44 is
is,
there. No,
it is order under section.
44 is the SCN in form of DRC
No,
01.
that is not SCN. Our brief shows it is.
No, 44 is something middle.
I'll make the
It is
decision.
middle. 43 is the order.
Mr.
43 is the
Mandala,
order belongs.
kindly
44
check
belongs to lot of people to appreciate. 44.
44 and 60 also not matching. 89 is matching.
44.
No, he's deriving that
Oh,
particular the expression. In the first paragraph, it says that the notice was issued vide this office notice number 5251 dated 2nd of July
Second.
2021.
Oh, you are not enclosed these notices.
No.
He wanted to highlight this
Okay.
from the first paragraph and then 60. No.
Well, let us see.
And 60, he says that is on this.
Last paragraph. I got it. intimation of tax ascertained.
30th July in payment of the tax and penalty.
So you have called out assessing authorities admission.
No, it's that since they have not challenged, so they have to accept as true and correct.
And my reply to the central authorities is an Annex 14 page 144.
What is the necessity of reply?
It's not, because I have objected that the state authorities have already done.
And it is it is not in dispute that you have not raised this issue. But they have said that those orders are not binding, or those orders are not effective orders in eye of law, because I have initiated a proceeding by issuing a summon. Now, after this judgment, the summon is not the initiation of the proceeding. Then what remained? So that is what is, brother.
At the end of the day, Lord,
I think 4-page order, not beyond that.
at the end of the day, Lord, I'm grateful to your lordships, because had your lordship not given me that liberty of an adjournment on 14th, I would have got hold of this particular judgment. Because this was delivered.
My lord is restricting my jurisdiction to pass more than 4 pages.
Not to pass.
Not to pass. Your lordship may put this.
That is what I say. This is the only thing is that this is what the interpretation comes.
Grateful to you.
For disposal of, or we can. Showing the disposal will be protection of this.
Item 20. Same and also GST Tribunal of Horse losses or
10%.
losses.
10% total.
Item 21.
My grievance in this case is, despite being eligible for waiver of interest and penalty with regard to the tax demand raised for section 73 of the CGST Act, I have been prevented from, and despite making the payment of tax as per Rule 164, I have not been able to upload my application on SPL 02 because of the erroneous order passed under Annexes 2 Lordship. In my case, assessment for 17, 18, 18, 19 were made together, raising demands under Section 73 and 74 both provisions. But when the consolidated demand order under Annex 2 was uploaded in the portal, it has been erroneously mentioned as only relating to 17, 18 and only under Section 74. That is why when I try to upload my application SPL 02 for waiver, the system doesn't recognize that there is any order under Section 73 exists in my case. That is why I could not file it. And I have made an application in this.
Why it is not?
My lords, my lords may kindly see Annex 2 DRC 07.
Yes.
That has been issued under Section 74 members.
Yes.
An amnesty scheme is not permissible when an order is passed under Section 74. Therefore, the system is
128A is amnesty.
Amnesty scheme.
So that interest part was waived out.
That is supposed to be.
So if it is the assessment is done under 73, that covers under 128A.
Yes,
not otherwise.
Yes. Since the assessment has been made under section 74, my lords, the system is not accepting the amnesty.
That is the error in the order. That is because the lordship will see.
No, what was the notice?
The
Notice was under 74 or 73?
73 and 74, both.
So,
Common note. Lordship may take up a copy to page 59 of the order in original. There, Lordship, different components of the demand raised against me has been given in seriatim, Lordship. There, against me, demand both under section 73 and 74 have been raised. And
how can it be on a different parameters for different period or for the same period?
These are
59, page 59 you are referring to?
Yes, order. I confirm
Order,
with
one is 73, 3 is 74. Mr. Mukesh.
Similar, I am only entitled to relief.
Yes, I could understand. Mr. Mukesh.
But DRC 07 only says
1 is 73, 3 is 74, 5 is 74.
What has happened, a consolidated order under section 73 and 74.
So how
can you do it? Both have a different facets. One is there must be an element of fraud, and in another case there is no element. Yes, misrepresentation. Then in that event, if you wanted a waiver under section 128, so far as those components are concerned, then why not?
Order has been but final order under section under DRC 7 has been passed under section 74.
It's not. Like if you have initiated a proceeding under section 73 by issuing a show cause under section 73, can you pass an order under section 74?
Show cause was issued for both the
Mr. Mukesh, kindly just quote the point which was asked. Can you club up both 73 as well as 74, having given two notices under 73 separately and 74 separately?
No, he says composite notice under section. That is
composite order for two assessments.
Can you?
Different provisions. 73 and 74.
Similar matters are pending the constituted notice and order.
No. One show cause notice covering the different periods is one aspect. Yeah, two separate notices, one under section a single notice, one under section 73 and the 74, both composite. If it is issued, can it be?
No.
So the learned seniors has not annexed the show cause notice, only the order.
Not order. Your order reflects. Your order shows. Your order at page 58, if you come, since I have already held to impose penalties under section 73/74 for contravention of the different provisions, I find no other offense having such and such. So you have already invoked both. And then 7, you talk about the 74 only, penalty.
Both the section, this order has been passed. So I will take
Have you given any finding with regard to fraud element? Or willfulness or deliberate or suppression of material fact? Have you given separately with regard to any turnover which has been escaped?
It has not been done.
Then how can you invoke 74 unless you have
They have
at least prima facie and a notice?
They have not challenged the initiation of proceeding.
Why should they come forward to justify your action?
There limited prayer that 73 what
Can there be an estoppel against the statute? Can there be an estoppel against the statute? If the statute does not bestow you power, then
taking instruction with the two notices issue has been issued.
one issue.
Even then, it will not make any difference, Lordship, because this consolidated order has been passed and both the components of the demand are there, 73 and 74.
So 2 financial years.
Yes, sir.
17, 18 and 18, 19.
18, 19. 2 years,
Ah.
both under 73 and 72.
Mr. Vikesh, if you come to page 63, that makes the submission very clear. Page 63, point number 2. Summary of order.
The manual.
Issue involved. Read it. Non-payment of GST amounting to such and such demand in SCN from notice under section 73(1) of the CGST and OGST Act for the period financial year 17-18. Full stop. Short payment GST so and so for the period 17-18 and 18-19 demanded in show cause notice from the notice under section 74. Wrong availment, utilization of ineligible ITC amounting to so and so and demanded under section 74.
Oh no, if you that makes the position more clear if you come to page 18 of the writ petition. That order, the first paragraph of the order, the reference, paragraph 1.
Yes, sir.
There is one show cause notice. The show cause notice dated 11/1/2022 issued to them such and such by the Joint Director, the Directorate General of the General of Goods and Service Tax Intelligence, Bhubaneswar Zonal Unit for demand of the GST amounting to rupees 1 crore and odd, CGST and SGST not paid for the financial year 2017-18 and 18-19 under section 74(1) of the GST. Further, the GST amounting to rupees 1 crore and 80 lakhs not paid for the financial year 17-18 was demanded from the noticee under section 73(1). So one show cause notice under both provisions.
There is no confusion there.
You were saying the show cause notice is not. That is what I'm saying. So there is a single show cause notice, both under section 73 and 74. Is it permissible? If permissible, then can you block or deny a right to claim amnesty, I mean the waiver under section 128 capital A, so far as the liability determined under section 73? Because you have initiated a composite proceeding, that does it mean that they are denied of their valuable right, statutory right?
And he has already deposited tax component.
Then in the meanwhile, they have also acknowledged.
So for a 74, I understand that it is outside the purview of 128. But 73 definitely comes. So.
And he has also pointed it to you at page 77. The authorities sitting tight over it.
Submission, he has filed a representation, my lords may.
You have to rectify. You have to.
My lords may direct to dispose the representation.
Since
very
March,
very bad bench you have chosen.
Sir, it is 31st March 2025 he has filed. We are in September.
No, directions under this.
We will say that it can't be. You have to open so far as the component of 73 is concerned.
You see your seal at 77, page 77.
Yes, my lord.
So why do you keep tight over? You ask your authority. Why is he keeping silent over?
I just want direct to dispose this representation.
No. You should come forward. Why he has kept silent? And
I will take instruction.
6 months, around 5 months, more than 5 months, and he is unable to, you will now proceed with.
For recovery also. They have in the meanwhile started recovery, including the. I got.
We will stay that. We will stay. This
When
cannot be-
when can you?
Within a week, check.
To don't proceed for recovery?
Don't proceed.
Don't proceed for recovery. But
Because it seems it is pending, 31st March.
Yes.
what is this? Any discretion,
when can you?
whether any discretion is given under section 128A?
No, 128 is special provision which gives.
No,
scope
whether
to
any
the-
discretion is given to the authority whether to allow or not to allow.
No,
Because the waiver is there.
Only certain conditions have been prescribed under Rule 164.
No, I was just looking at it.
Plus.
So nothing is given. It simply says once you pay off and comply the conditions, then
Within the period stipulated, I have made the payment. 30th March, I have paid.
yes, take instruction within a week. What an interesting one. Very interesting.
You get all these cases like this. Very interesting points to ponder. Mr. Haushal always comes forward with such complicated issues.
Only those come to me, that's it.
No, don't. There are many.
Urgent to. Whether you allow by opening your portal, that is what is.
We want it.
As a special case, you do yourself.
In another.
Or do whatever he has pointed.
In a somewhat similar case, lordship had already disposed of one matter where the demand was 0. So no payment could be made. In the portal, the demand showed as 0. So in lordship had disposed of, directing them to open up the portal and allow.
So they have to. Description they have to apply.
Because we are going to do that.
Lordship. In this case, lordship 17/6/06/2025.
In any cases, my lordship has directed for opening the portal.
So now we will not die. You will do and confirm.
Yes.
9 September. Item 22.
It's 15. It's 15. Why? Portal has to be open some given time as well. Yes, some formalities to take.
Instructions.
Instruction that we are going to open a portal. You have to just say, otherwise we have to pass the order and they
Urgent to 9 September.
In the meanwhile, it is not take any.
Thank you.
Okay.
Item 22.
So in this case, what is challenge for receiving loss? The communication by ITU TPS Sambalpur, there's under instruction from direction of this principal commissioner There's income tax central Visakhapatnam. That's for transfer of case from one assessing officer to the other. That's purportedly under section 127 of the Income Tax Act. That's 127. There's presupposes we have to provide for two main conditions to be satisfied before invoking clause 127 for transfer of one case from one assessing officer to the other. It's not a matter of course unless situation so arises, a reason so persists, giving rise to invocation of power. This is not to be done. So therefore, two conditions as 127 speaks of errors. One is there must be a reason which is to be recorded by the principal commissioner who is directing the officer concerned to transfer the case. Which commissioner? There's a principal commissioner exercising territorial jurisdiction over the assessing officer who is the, but there are two officers. One is transferring assessing officer, other is transferring assessing officer. Where the transferor assessing officer over which will territorial jurisdiction enjoyed by the principal commissioner, he has to apply his mind. And if he finds that there are situations necessitating transfer of case from him to the other one, whereas he has to record reasons for transfer. One. Second condition, whereas before doing so, he has to give opportunity of hearing to the assessing concerned mirrors. So these two conditions, Honorable Supreme Court has held. I will tell you also the judgment, and that is also followed very recently in January 2025 by High Court of Himachal Pradesh. January recent judgment. Here, what has been done, mirrors? Whereas I am running mirrors a outsteel liquor shop mirrors. Outsteel liquor shop. I have been filing my return in IITO Rourkela mirrors, and all the mirrors of processed income tax returns mirrors under 143(1) mirrors which I have been assessed mirrors on 143. That is annexed 1 series. The last 5 years I have given. Those are there. I have. So mirrors, what has been done now? There's Principal Commissioner Visakhapatnam under 127. My first point is he has no jurisdiction at all. If at all such a measure is required to be taken for the purpose of transfer of case from one assessing officer to the other, it is the Principal Commissioner who exercises power, territorial jurisdiction over the assessing officer from whom the record is required to be transferred. And it is the Principal Commissioner Sambalpur mirrors. Because ITO Rourkela falls under the territory.
Because the assessing officer of Sambalpur wanted to transfer the proceeding to Visakhapatnam.
No. Visakhapatnam
wanted to transfer. They initiated a proceeding.
ITO Sambalpur, PPS Sambalpur, correct. In communication which you are the challenge before Lordship Annexation 8 says that I am under direction from Principal Commissioner Visakhapatnam, yes, for transfer of case to DCIT Cuttack mirrors.
Cuttack?
Yes.
So according to you, it is the commissioner over who exercises the power of jurisdiction or power of superintendence over the ITO.
ITO Rourkela.
Sir, he can pass the order for transfer, but not the commissioner who has
correct.
not exercised.
Absolutely correct.
Absolutely power of superintendence.
Correct. That is one. And number two, before doing so, as I said, let me reiterate, he has to satisfy two conditions. He has to record results and he has to give opportunity of hearing.
According to you, merely on the instruction of the superior is non-application of mind, and therefore he cannot.
Correct. He has no jurisdiction also. In the very beginning, because at threshold, he has no jurisdiction to choose. It is only jurisdiction lies with the territorial principal commissioner clause under 127(2) of the Act clause. Now, what has happened? That's your lordship will find.
What has happened? He has transferred.
No, till now I don't have anything. My majority didn't stop here. That's what has happened in this case. Yes, search was conducted in the place of business of one assessee, and he has two concerns. One Hingora Transport and other one was Vikram Sahu. Those two assessees, their place of business was searched by the Income Tax Department. Now, I got a letter from the, there are 5 letters, communications made to me, after and before this transfer case, communication, saying that because you are connected with that, so therefore you are required to.
You are connected with them.
I don't know. As your lordship rightly said, except that there is one sentence, and that I came to know for the first time when this transfer of case Annexure 8/127 is issued. For the first time, and that is the reason also. Only saying that I am connected with that, so therefore this. And prior to
No,
this,
it must be there that they are in the transport business, your materials might have been.
exactly, nothing, only saying that you are connected, that's all. And prior to that, the other three communications, those are issued to me, saying that you are required to, one is 131A notice, other is 133.6, and different provision by different officers. I have the list of communications, so one notice is issued by the annexure, 1. Sorry, 1, 2, by annexure 2, that notice was issued by DDIT Bhubaneswar, Deputy Director of Investigation in Income Tax Investigation, Bhubaneswar. Annexure 3, 5, and 6, these three notices are issued purported 136 by ITO Investigation, Cuttack. And ITO, and annexure 8, that is the improvement which I said that ITO BPS Sambalpur. Whereas all these communications are premature unless transport takes place under 127. Exercise of these notices and calling for documents, these are all premature. So therefore, my humble submission is annexure 8, which pertains to this improved transfer of case from one receipt officer to the other without complying the twin conditions, is illegal. And other communications which are purportedly
which are dependent upon the original one.
yes, keeping in mind as if transfer has taken place, they have issued, those are premature also. Because if at all transfer of case will take place by following due procedure of law, then all these may take place. But it cannot either procedure that cannot follow. So, and nowhere, because I have in my reply, you will find detailed reply in the brief which I give to Rossi Bhatt. I have clearly stated that why this is so, in what connection you have, what reason you have, there's nothing. These are not communicated to me in any manner. That you also I am showing to Rossi Bhatt. Annexure 7. You also kindly see Annexure 7 at page 86. Annexure 7 page 86. Here your lordship will find there are several reference to several communications, and those communications which require me to make compliance mirrors, that also I received the leads by some are by speed post and some registered post, and the date of communication also have stated in my reply, and those are post the dates requiring me to comply mirrors. Your lordship will find. If your lordship permit me, paragraph 2 at page 86. That after appearance before you on 17/4/25, we came to know that say documents were issued to me give evidence in sources of Vikram Sagar and Ma Hingula. During this appearance, you have asked me that there is any business interest of so and so in my business, a country liquor manufacturing sales. I am the country liquor manufacturing sales up in the name of Parlada OS shop situated in Parlada district, Honorable Odisha, in which I am the proprietor and licensing license bearing number so and so granted to by Department of Excise, Government of Odisha. I have been granted excise license also. In answer to question, I have clearly clarified that there is no business interest of Vikram Sahu in my business, and I was residing at Raukela, which is 130 kilometers from Parloda. Only he says that I have told Vikram Sahu to occasionally look after my business, supervise the staff engaged there, since and deposit government revenue on my behalf in case of emergency, as Mr. Sahu is close friend and was residing in state district headquarters Honorable. So only this. Then so also may kindly see paragraph 6 regarding notices to produce all information books of account documents commencing from 18, 19, 22. I have to say that I have no business interest with Vikram Sahu, which name the search warrant has been issued, and the waste manufacturing sales up at Parloda name and style of Parloda waste is owned by me, and the government of Odisha has issued license in my favor bearing number 1 for manufacturing sale of liquor. I am depositing state excise duty Odisha, VAT, income tax on that shop with honesty and utmost sincerity. Furthermore, I am questioning you that this is somehow he questions himself. That has Vikram Sahu admitted the statement recorded by you during the course of search that he has in business interest in Parloda Voice Shop in which I am proprietor. Neither a search warrant has been issued against me nor my place of business has been searched by your good self. I have to say that under which circumstances, under which provision of income tax you are calling for information protection of accounts for last 6 years, commencing so and so. For without reason, you are unnecessarily connecting with search of Vikram Sahu and Ma Hingula. Your business, you are harassing. All these are grievances in his own language he has stated so. And the next page, you will also kindly he has given details of his own business turnover for last 5 years. And in the last paragraph, he says It is therefore prayed that in view of the facts stated above, your yourself may graciously please to give a reason in writing why you have been unnecessarily correcting me in the search case of Vikram Sav and Ma Hingula by issuing several notices for production of bookshop accounts for last 6 years, commencing from 89 to 29. For which I served. So, despite of all these mirrors, then came mirrors, this annexed 8 mirrors, which your Lordship kindly see now the transfer of case notice.
Who's that I have seen this interview?
Yes, page 90. Correct.
I have read.
Correct. And the language your Lordship will centralization, that is also not conceptualized or contemplated under 127. That only speaks of transfer. No question of centralization. Anyway, that is the language he has used. But centralization is not a thing that is envisioned in section 127. Then I also didn't give month. I responded also.
So you wanted to challenge this particular notice.
Correct.
And if the notice is for the time being of the day, then that even the other communications should also fall in line.
Correct, absolutely. So precisely, my lords, I have taken a brief, concisely what I relief I am seeking from my lords, my lords. First is the principal commissioner, my lords.
The first point that where a commissioner of another jurisdiction pass a direction on the ITO or the assessing officer of another jurisdiction to prosecute the system.
And number 2,
can visualize it's a transferable job. Apprehending
correct.
He may come to this jurisdiction.
Contact.
So he has obliged, and he has complied. So what is the wrong in that?
Absolutely.
You are agreeing?
No, I am not agreeing.
Is there any territorial jurisdiction is given?
Yes.
That must be separate notifications.
Correct, Mirrors. And not only that, but the statute itself says so. The Lordship will see.
Section 127.
There's 120, section 120 read with 124 mirrors, speaks of jurisdiction of the assessing officer. And the definition of assessing officer is also there in the statute itself. That is section 289. So as your Lordship rightly says, the territorial jurisdictions, the jurisdiction of the assessing, who is assessing officer and how the
So the return is filed, but
that is a jurisdictional officer.
And normally we not the jurisdiction he can assume jurisdiction where the assessee is situated carrying out business or where the office exists.
Assessing
That is
officer.
precisely we not, sir.
He says from one assessing officer subordinate to him.
My assessing
officer.
Yes,
He is
that's
an
right.
assessing
Correct.
officer.
Correct.
Subordinate to him. So now subordinate means immediate control over that particular officer. There is not the power is given. Oh,
Section 127 clearly allows to consolidate the proceedings.
no, there is no difficulty. But consolidation or a transfer of the proceedings, there are two concepts.
Right.
The transfer with an intent to consolidate is one.
Right.
And another is a simplicity transfer from one assessing officers to another for various reasons, maybe multiple reasons. So we are not going into it. Question is that who can command the officer to transfer? Because this power is given to the commissioner under section 127(1).
So 3-4 officers are named there. Principal commissioner is one of them.
One of them.
Right.
Now, if it is power is given to him, then whom he can direct? an assessing officer who is subordinate to him. Now, if a principal commissioner of another state, can he has?
Well, it is not in other state.
Yes.
Sorry. In case of investigation, it is conducted by the Visakhapatnam, the central zone. In case of search and seizure, so it's a matter of search and seizure.
On the Visakhapatnam principal commissioner
Yes, madam. Yes.
to exercise powers over Odisha territory.
Yes, madam. Yes, madam.
Where is that?
Where we wanted to know what is the meaning of this word, an assessing officer subordinate to him. I just wanted to know what is the meaning of this expression, subordinate to him.
The proposal has been initiated and approved by the principal commissioner
of Visakhapatnam.
Yes, madam. Visakhapatnam is the central zone which conducts search and seizure operation. And Odisha zone is coming within that with ease.
He can make a request to the principal commissioner or commissioner of this particular zone that this is what the problem, you take an initiative. Then he can command him to transfer. I can appreciate it.
Well,
but can he directly exercise the power?
And 127 is not for investigation, madam.
Same rank officer is available in Odisha also.
Yes.
Well,
So
but the search and seizure operation.
that you have to have one notification of territorial jurisdiction
Right.
over which he has to exercise the jurisdiction.
That I will take instructions.
Powers.
I will submit my that notification. I will submit that notification.
Merely some
Right.
authority is declared as assessing authority. It doesn't assume the
Finally, visualize the situation. Subsection 2 is also very
Clear.
important.
Yes.
One is subsection 1, where the same assessing officers both are within his subordination.
Correct.
2 says where the assessing officer or the assessing officers from whom the case is to be transferred and the assessing officer or assessor to whom the case is to be transferred are not subordinate to the same principal director general or such as that we can skip principal chief commissioner or principal commissioner or commissioner. Then in case of first A, where the such and such commissioner, principal commissioner to whom such assessing officers are subordinate are in agreement. Then the principal commissioner or commissioner from whose jurisdiction the case is to be transferred may, after giving the assessee a reasonable opportunity of hearing, whichever is possible, and recording to pass the order.
Well,
So he can request the principal commissioner here, and then the transfer can be effected. There is no agreement.
not in agreement. B is not in
Not in agreement, then notification. Board.
By board, yes.
Board by notification.
By notification.
In the official gazette can do it. How can he straight away? I don't know.
when I will take the instruction, I have submit the notification. Your Honor.
Then except, sir. This case was still. If I cannot move,
I'll produce my Your Honor, I will produce a notification. The last part I'll tell you.
When can you come back?
Next week,
in the reply, he has directly thrown the challenge to your authority boldly. Yes. What to do?
Well, next week, I will take the.
Has he passed an order?
No.
Anyhow, he has not passed an order. Take an instruction because we have found that it cannot. The notice itself is bad.
Right.
If notice is the initiation. If it is bad, then everything will fall. Do whatever you do. This applies when the principal commissioner exercises the power and passes an order for transfer.
Right.
Here, he has given an instruction and the proceeding is initiated by a assessing officer to transfer. Now what to do?
Right.
Please consider that and come give a reply.
Right.
Your lordship may not write words from, only they said that will be centralization with DCIT court. They don't say from. But invoking section 127.
This is that we have given, my seen the notice, it says 127.
Minus.
I'm ready.
Right.
Yes.
Adjourn to 10 September.
So my humble submission, election 8 minutes may be stayed in the meeting.
Oh, nothing. They are not going to do that.
Item 23.
Still no final order.
Item 23.
I don't know what they have done, but I don't have anything.
They have not.
Let me make a submission to what we have, as usually we not. Because each and every time your lordship will find a repeated notices are coming back. Just one, something for versus mouth so that I can protect him.
Item 23.
Handled on behalf of Mr. Monte. And it's the plan. 2 weeks.
You are the writ petitioner.
No, my lord, I am for the respondent number one, private respondent number one. They are the, I am for the writ petition.
This is the university of it.
No, my lord, I am for the respondent number one, the private, I was the writ petitioner.
That is what
My
I am
lord.
asking. Are you a writ
My lord,
petitioner?
I used to get the appellant.
Because
Yes,
Pradeep
sir.
Kumar Patna hai.
My lord, I am for the.
And we give 2 weeks time.
Be in contempt. Those 2 weeks, that is
18th September.
May indicate that they have taken adjournments on a number of occasions. My lord may say that this is for the last time. Last time, right?
Well, the tendency of the instigative does not prevent the writ petitioner to proceed in progress.
My lord.
Item 24.
You paying for adjournment for one. I'm paying for yesterday. I'm the petitioner level of 100.
Urgent to 11th September. Item 25.
I am asking in this case, say, and for me to file the vocal minimum. Because of in person is entering in this case. In person, yes. So I will my author. Yes.
Is he filed in person?
Yes, sir.
No, you filed it. The last petition he was arguing.
Yes.
Since you have filed.
My name is not reflected in God.
You did not file the Vakalkama at the time of filing. So he was also in person. So we have asked him to release you.
Yes.
He asked him either to get a recusal from you.
Yes.
Otherwise he can't.
Yes.
Now he wanted you to argue.
Yeah, no, your lordship, he, as per the instruction of that appellant, today I am appearing, your lordship.
What is your name? You filed the appeal or not? Appeal was filed by whom?
It is under your signature and seal, sir.
Lordship,
The appeal
my
is filed.
My name is not reflected in the cause list. That is the legitimate.
You did not file. Your Vakalkama while filing
That's
the
it,
appeal.
Yes.
But you have signed and sealed at the time of filing.
Yes.
So the person was again
Yes.
this case.
No,
Then
name.
you are right or not to follow.
No, actually, difficulty is that your lordship, who had been in this case, your lordship, the honorable single judge has not considered as per the judgment of this coordination bench, your lordship. May I permit your lordship raise this judgment.
25.
Has not been considered to in the lead petition, your lordship.
You had any alternative remedy?
This government belongs to Srinivas Kar versus State of Odisha. On the ground of sympathetic it is engaged. Yes.
What is the question of consideration? So you have operated remedy which this is include in the restriction.
And they you also can be taken.
Include out of the.
That is your lordship.
What happened to this Bhakta Nayak's case?
Yes,
That is, writ appeal is pending, Malad.
Writ appeal is-
Writ appeal is pending, the next date is fixed to 18th of this month. The writ appeal, in the writ appeal.
Before who?
Malad, the writ appeal is supposed to come before this bench, this honorable.
No, yours. Delay, 200 days delay is there, and state has come to the lordship.
Delay
Only
condoned?
not condoned, Lord.
Not condoned.
Not condoned. And that has not been discussed 1 second before your lords.
Let me see.
As per mine.
So in Bhakta, what has been held?
Yes, sir. That has been your lordship allowed. The petitioner. The engagement.
Is now page 13.
It was 779 of 2010. The prayer in the restriction was to issue direction. We give you accountability.
Yes, sir.
As junior teacher.
Yes, sir.
As was directed.
Yes, sir.
In 13779 of 2010.
Yes.
And 14548 of 2010.
Yes.
Right.
Yes.
There, one of the paragraphs in that 13779 that indicates that standing counsel for full and mass recruitment department has no objection. We clearly submitted that in case vacancy is available, the case of the petitioners can be considered in the light of the above opposition made by the person as well as if any vacancy occurs in the district of Toronto as indicated by the director of Toronto so far as so is considered. Right. So that is based on concession.
Yes.
So you want this concession to be so Mr. Sanjay Raj also application. That was the division was
Corrective portion of the judgment of that.
But the operative portion, my lords will find at page 17.
Bread price. 17, no, not said so. I know the reading page, the paragraph, sorry, page 14, 13 onwards.
No.
Where the earlier order was quoted.
No.
Oh, from the writ petition, annexure 1.
No.
As per the judgment of moment in 9 days.
The order challenged in this writ appeal, my lord, that is at page number 14, which is annexure 1. Another order starts at page 15, my lord, that is annexure 2. My lords may kindly see page 14. The page after the prayer at page 13. It's a one-page order. This is WPC number 12357 of 2025. This order is challenged, my lord. The next page, the order is another writ petition. That is not challenged in this writ appeal.
No, that is a separate.
That is a separate writ petition or separate order.
That is a
So they have
separate.
challenged this one page order. No, writ petition, my lord, I do not have.
The writ petition, please, 26 is the very important. I'm ready tomorrow, go through it. When there is an order, because what we find is the implementation of an order which is part of substation. That cannot be.
And this prayer
Item 32, you know, see permitted to direct.
Tomorrow. Item 30 tomorrow.
No.
Item 30 tomorrow. Yeah,
30.
30 tomorrow. Actually, a transfer plan.
So why don't you give it first? This is logical matter. So give it first. Tomorrow.
26, but the next item not question. 26, next item.
Yeah.
Can be taken out tomorrow, Madam Chair.
Let us see.
43.
Your lordships, item 38, your lordships, national emblem matter. Both that two will.